Hypocrisy.
Hey, what's up, guys? Welcome to Lost Planning the Interwebs. I am your host, Nick Rekieta of Rekieta Law, a small law firm in central Minnesota. How we doing today, guys? How are we doing? I hope you're doing well. I hope you are doing well. Tonight we are talking about Tyler Robinson. This case is, of course, like fascinating everyone, me included. But we're not just doing slop content on it, whatever that means. We're doing real content. We have documents that are new to me. It's new to me. It's not new to everybody. Some of you have probably seen something about this. I don't know who else does like the full document read through or analysis. I don't know who's doing that other than myself on a couple documents. We have the prosecution's reply. The prosecution's reply for the preliminary hearing. And this is, of course, still on the issue of bind over. Believe it or not, even though it feels like a fucking lifetime, we don't know if the judge is going to bind over Tyler Robinson for trial. I think he's gonna. I think that's gonna happen. But, you know, we don't technically know yet. Technically, he could decide no. So we have this reply, and this is the last document. This will be the final say from the attorney teams on this. And then the judge will render his decision based on the filings and the law and all of that good stuff. But I figure it's probably a good idea to go through it. And I did take a little preview of it this weekend personally to analyze what, you know, just to get a basic synopsis of what's in there, because I figured I'd probably be covering it when I got back home. And I got to tell you, the prosecution's pissed. They're fucking mad. Where's your glasses? They're right here. They're right here. Nobody's ever happy. There we go. Now we're cool again. Now we're cool. I might keep them on. I might take them off. We'll see. We'll see. But yeah, so I did take a preview of it. The prosecution is legitimately angry at the defense. I was a little surprised to see that come through in a Utah court filing because, you know, Utah is very reserved, conservative, typically. You can read that as boring and gay if you want, but that's bigoted or something. That's bigoted. Also, I hope the thumbnail that I made was very disturbing for you. I hope that is very, very disturbing. But okay, so we're going to go through that document. I think it's 19 pages. It'll take a decent amount of time, but not all of it. You know, the issues are not fresh. This is a reply brief. So the way briefing goes is the first party, depending on the circumstances, goes first. In this case, the prosecution bears the burden. So the prosecution goes first. Then the defense gets a response, and then the prosecution gets a reply to the response. And that's it. That's all the briefing that gets done. Outside of some weird circumstance that I don't even know if there's like a specific rule on, the judge would have to order it. Doesn't matter. Judges can kind of do what they want, as we've seen. We're not getting into that. We're not getting into that. But so this is the final word from the attorneys teams on bind over. Let me just give you a preview though. Bind over is going to happen in the case and likely on all 7 counts. All right, because the probable cause standard is very low, and the prosecution hammers why this is, in this case, why bind over is basically a foregone conclusion. It's never actually a foregone conclusion, but it's basically a foregone conclusion in this case, and that's just because of how probable cause works. Don't mistake that though for them going like, well, we have a questionable case, but we at least made it to bind over. They fucking obliterated bind over, like the probable cause standard. It's obliterated. There's so much evidence in this case on all of the counts, the weakest ones being like witness tampering, and they got pretty good probable cause evidence on those. I don't care about those. But they have like an obscenely strong murder with the death penalty case. They have that. They've already presented part of it, and it's devastating for Tyler Robinson. They also have the violent offense committed in front of a minor. They have the minor that enhancements on like every crime, just about. Those things are basically locked down. Obstruction of justice, pretty solid because it goes back to the admissions. Just like the admissions to the murder, you've got the admissions on the obstruction of justice. And I'm not going to tolerate any. You will be banned, not from my chat, but you'll be banned from smartness. If anybody comes at me and says, yeah, but couldn't those texts have been faked? Well, sure. Anything could have been faked. Anything could have happened, but it didn't happen until we have evidence that it did, not that it maybe could have somewhere. We're going to dispel that tonight. I'm done with these stupid caveats and qualifications, which is why the disturbing thumbnail says weird things. Everybody keeps saying weird things. Bullets do weird things. I'm guilty of it. I've said this. Bullets don't do weird things. All right? Let me repeat that. No bullet in the history of humankind has done anything weird. Bullets have encountered circumstances that we may not have considered or predicted, but they act predictably, very predictably. In fact, if you can't do this. It's literally impossible. But if you could repeat the exact same circumstances, you would get the exact same result every time. Now, it's impossible. There's wind. There's a different amount of fluid. You're on an off heartbeat. If you're off by a millimeter of where it hits, it changes everything. Sure. But if you could replicate every single bullet fired, if you could replicate the conditions under which they were fired, it would happen exactly the same. That means that bullets don't do weird things. It means you may not have thought about what the bullet would do. Because why would you? It's not your job to sit around thinking, you know what happens if a bullet does this? No, of course not. That's not just true for the bullet, though. That's not just true for the bullet. It's true for every fucking weird thing in this case. This case isn't weird. This case is normal. What's weird about it is the circumstance. We don't have a lot of assassinations. We just don't. We don't have a lot of assassinations of Charlie Kirk. One on record. We don't have all of these things happening all the time. So we're not thinking about them. We're not looking at them that way. And in fact, I'm going to posit most people are bad at these things. Most people who are trained to be good at these things are bad at these things. And some of you work in professions like this. Some of you work in professions that their value is the presence of the person or the team or the circumstance that the business brings. Private security, TSA, but the performance of these entities and organizations isn't always great. And there's a lot of reasons for it. But mainly, they function because most people aren't trying to murder Charlie Kirk. You know how we know that? He didn't die sooner. So we know that most of the time, nobody tried. The overwhelming majority of the time, nobody tried to kill Charlie Kirk. One time we know they did, they got him. And that may be an indictment of private security. I know that like Brian Harpole or whatever, Candace Owens said like he's incompetent. And it's easy to see incompetence in a job with such a high risk factor. If you fuck up at private security, the principal dies. But you know when else the principal dies? When you do everything right, but something happens that you didn't predict. Because you can't predict everything. In fact, most of the time, you can't predict goddamn anything. So we're going to talk about private security because people don't get it. They're like, well, why didn't they do this? It's like, you know that now. You know that now. You know what happened. So you go, well, why didn't they do the thing to prevent what happened? Oh, I don't fucking know. Good call. You're very brilliant. They should have had you on the team. You could have thought about the thing that they didn't think would happen. Not that they didn't think it would happen, but they didn't consider happening. They didn't think someone was going to climb to the top of the Losi building with a fucking rifle and shoot Charlie Kirk that day. Nobody thought that. Nobody on earth. Not even Charlie Kirk. I know there's a text message out there that says he's afraid the left is going to kill him. He's like, I'm afraid I'm going to be killed by the left. What is the left? Is Tyler Robinson the left? I mean, Tyler Robinson may be a leftist. He may not. I don't know. I don't really care. That text message is nothing. It's fodder for, inviting people to click. That's not a slam of the presentation of that text. That's the purpose of it. It's the possession of and the presentation of that text is to get people interested in something they haven't seen. That brings them in to be educated on a subject that they are thinking of. And if you can only get it in one place, you're going to get that perspective. But that being said, him being scared of the left means nothing for the next day when he's shot and killed. Because the left didn't make a threat to kill Charlie Kirk that day. There's no chatter from the left about murdering Charlie Kirk at UVU. None of that happened. We don't even have evidence that Tyler Robinson told anybody what he was going to do. There's no forum post. There's no manifesto. He said he was going to take it to his grave. He thought he would get away with it. Whoops. Turns out he was really fucking bad at getting away with it. Really terrible at it. Left evidence everywhere. Remember the good old days when he sent to his deep-voiced and deep-throated gay boyfriend, and he's like, if I grab my gun, I won't have left any evidence. Well, I mean, except a whole bunch of it. A whole bunch of video. The ALPR cameras, the surveillance cameras, the GPS data on your phone. Whoops. That's a bad one. We haven't even really talked about that. We don't even know what's in his car infotainment system. He left a decent trail of evidence. That's how they were able to find him. And then he confirmed all of it. He confirmed all of it in text messages that came from him. They didn't come from someone else. Stop it. Stop it. The reason we know they didn't come from someone else is because that doesn't make any sense. That doesn't make any sense. That doesn't even make sense in the conspiracy. Oh, well, they needed a patsy. Okay. They had to make it easy to find him. They had to have the admissions. Why? I thought he wasn't supposed to live through it. He was supposed to die. But then he didn't. Not only did he not die, they even had a perfect excuse. The Jews could have killed him later because he was considering suicide, according to his parents. And by the way, his parents did say, for the purposes that we have, his parents said that he killed Charlie Kirk. Now, I know, diligent denizen or whatever, the dumbest person maybe on the planet has apparently talked to the grandmother of Tyler Robinson, and she thinks her sweetheart didn't do it, And she swears the rest of the family feels the same. And she says the parents never said that. Well, the parents did say that. And we know the parents said that because it was independently reported from each of them in their statements made when they brought Tyler Robinson to the police. And all of them were interviewed. All of them independently interviewed, independently corroborating that story. They haven't come out in any capacity to say the police forged that statement, they lied about it, blah, blah, blah. Nothing. Now, they may not have expressly said, Tyler told us he murdered Charlie Kirk. It might not have been that explicit. We don't know the exact phrasing, but they're going to testify to it. But they're not going to testify at pretrial because testifying at pretrial traumatizes them. They're putting their little baby into prison. Hard thing to do. So they're going to bring them in when it matters. When it matters. They're going to bring them in at trial. If it goes to trial. And the only reason it's not is a plea agreement. Okay? But that's when they're going to bring them in. They're not going to burn that resource at the beginning. Same thing with Lance Twiggs. That's why we got a sworn statement interview with an attorney from the Utah prosecutor's office. And he now, people misunderstand that video. That's a statement from Lance Twiggs. That's not testimony. That's a sworn statement. The presence and the purpose of the attorney is to facilitate a verbatim statement. So any questions he may have asked or whatever, those are to get to the meat of the statement and get it on file. It's not an examination. It's not a cross-examination. That's not what happened there. It'll be different at trial. At trial, he'll have to go through direct examination and cross-examination. That's real. That's going to happen. And the defense may elicit some testimony. They may do something to make it seem like Tyler didn't do it. I doubt it. You know why? Because Tyler did it. We got to stop pretending. We have to stop this nonsense. Candace Owens has brainwashed a bunch of dumb people by being dumb. Dumb people like other dumb people. I don't know if you've noticed this. Dumb people don't really like smart people very much. They love other dummies. Like, I understand this person. They must be brilliant. No, you're just retarded too. She has hoodwinked so many people. I don't think she's even trying to. I think she's just legitimately an idiot. And the reason I say that is because everything she says is stupid. All of it. There's nary a smart statement coming out of those lips. But a bunch of dummies agree with it. And not everybody who agrees with Candace is a dummy. Of course, if you're smart, you know I'm not saying that, even if you agree with Candace. Only the dummies are dummies. But it's time to stop fucking pretending, and it's time to stop pussyfooting around, and it's time to stop giving any credence to people who've been routinely discredited on this case. And that's Candace Owens and Baron fucking Coleman. Baron, the former government shill Coleman. I've only seen two things from Baron Coleman. One, this case, in which he's a retard. Bumbling, mouth-drooling retard. He said someone was guilty of, or bordering on criminal, what was it? Criminal misunderstanding or something. Which is perfect for him saying that because it was idiotic. It made no sense. But I know him from this, and I know him from the only other case I've seen him work on, which is Gavin McInnes versus the Southern Poverty Law Center, which I believe he's the author of the original complaint, which I reviewed years ago. I didn't know it was him. I figured that guy would have offed himself by now for being so shitty. But he wrote the worst fucking complaint. It's awful. And that case is just sitting around in hell. You know why? Because the complaint was so bad. So bad. But the only things I know about him are terrible. He's awful. That's going to change. We're going to start looking into Barron a little more, and we're going to be reviewing some Barron Coleman videos and commentary soon, because anybody can sound smart, learned, educated when there's no one to ever check them. I know. Look, it's me. I do this every day. I got a bunch of dummies convinced that I'm a genius. But we're going to dig into Barron Coleman because he is either dishonest, which is likely, or flat fucking moronic. Probably both. Probably both. But we're not going to do that today. That's coming. That's coming. But a lot of it will have overlap with today. You know why? Because we are going to eventually get to talking about the gun, which is the murder weapon. It's the murder weapon. It is the murder weapon. It's the murder weapon. It's the murder weapon. Yes, we have the murder weapon. The evidence that this gun is the murder weapon would be a dream for most prosecutions. Now, some prosecutions get really lucky, and they do get a nice tool mark review of the bullet, and it confirms the rifling inside the barrel and some other microscopic. They could do a confirmatory test. Great. Didn't happen in this case. So what? That's one piece of evidence. And you know what? People are actually fighting against tool mark analysis. And you know why? Because tool mark analysis isn't magic. It isn't science either. If you've watched this channel and watched other trials that involve tool mark analysis, Murdoch, it's a little bit of hocus pocus out of focus. It's all about how artistically, someone compares the marks on one bullet and another and determines that they are close enough to be inclusive or exclusive. That's it. But it is a determination made by someone looking at tiny little lines through a microscope. They use a comparative microscope. They pull them both up at the same time. It's cool. But it's also a bunch of fuckery. And defense attorneys attack it all the time. And tool mark analysis probably isn't going to survive. But the reason it's not going to survive is because something better is going to come along. And when we have a better way of analyzing evidence, we use it. And guess what? Guess what? One of the first cases that's going to use the next wave in bullet analysis is this one. I don't remember what it's called. It's called like microscopic metallurgic alloy analysis or some virtual whatever, VPM. We can look it up, but it doesn't matter. They haven't done it yet, but they have asked the court for it. Now, this is probably going to undergo what's called a Rule 702 challenge in Utah, better known across the country as a Daubert challenge, although Utah has some specific rules and requirements. And Utah uses the Daubert sort of process to either allow or exclude expert testimony on a certain scientific method. But the ones who want to use it, of course, bear the burden of showing that it's a reliable, repeatable scientific process. Now, this is a new procedure. Now, it's got a lot of research behind it, and it's like nothing's new, right? When we hear about new scientific stuff, they've been doing it since, like for the past decade. It's been in trial, like it starts in a university laboratory, and then they develop it, and then it goes out to some private testing firms who they do their quality control on it, and then they run like surveys and have other people and other experts look at it. And it goes through a really long process before something becomes a solid, reliable, I was going to say unquestionable, but everything's questionable, including sexuality of Lance Twiggs. But a reliable process by which we can measure something. In this case, it's going to match bullets to guns that can't be otherwise matched. Like that's the purpose of it. That's what it's for. And I don't know the process. I don't care. We're going to learn about it at trial. We may look into it before trial. They've asked the court for permission. It's going to get challenged and we're going to have a hearing on it. It's going to be great. It'll be perfect content because it'll be something that you've probably never seen before because I don't think anybody will have. Certainly not in a major case in Utah like this. So we're going to get that. And that'll probably end up confirming that the bullet, like specifically that the bullet came from this gun, because that's ultimately the goal, right? But we don't need that. That's not always present. Going back to the tool mark analysis that's used, it's matching lines, microscopic lines on a bullet to the microscopic lines on another bullet. And they're actually never a perfect match. It's impossible to have a perfect match. You can have a really damn close match, but it can't be perfect. It can't be perfect because just by the nature of how metal works, there's wear every single time. And when you're getting down to microscopic levels of analysis, even the smallest amount of wear changes things. Now, it doesn't change things very much. Don't misunderstand me. If you fire a bullet from a gun and then wait 5 days and fire one more bullet from the same gun, there's nothing that's happened in between, they're going to look really similar, right? They are. And that's why it works. That's why we're able to fingerprint bullets to guns, is because of this analysis. But even it is not perfect. So if they've come up with a better way to do this, and they will, they always do, the old way is going to go the way of the dinosaur. But again, none of that matters because tool mark analysis is not the way we've always identified murder weapons. It's a helpful piece of evidence. It's a very strong piece of evidence. And I will argue, though, the tool mark analysis in this case is not harmful to the prosecution. It's actually harmful to the defense. It's just not a nail in the coffin for the defense. But so what? Most of the time it's not. Everything else about this gun points to it being the murder weapon. Everything else. There's nothing about this gun that says, you know what? Maybe not actually. Not a damn thing. And that's the amazing thing about this case because that's everything. That's every piece of evidence when we start to get into what they actually have. That's every piece of evidence for what they've presented so far. They put their most, I shouldn't say this. I should not say they put their most ironclad. They put ironclad evidence down. We don't know if it's their most ironclad evidence, but they put ironclad evidence down for the pretrial hearing because they want to lock down bind over, but they don't have to share everything. Not everything's done, right? But they put down pretty ironclad stuff. Notice the defense didn't challenge the evidence. They tried in a couple places and they failed. That's because it's good evidence. It's very good evidence. They didn't even challenge the video, the grainy video that you can't see. Everybody making a big fucking deal out of that because they don't understand how trials work. Grainy video that you could barely see anything from and you can't make out the gun all the time or whatever. That's common. That's normal. That's been the way we've prosecuted murders for some time now. Everybody's spoiled because you have a fucking 4K video camera in your phone. But those aren't everywhere, and they haven't been everywhere very long. Speaking of haven't been everywhere, we have a big raid from Cecil. Cecil says, over on Rumble, welcome, Cecil and his viewers. A good friend. Stunning man. You guys need to check out Cecil Says. He does the Cope Files, I think they're called Cope Files, Cope Streams, whatever, where he watches people cope with shit online. It's very, very good stuff. All right. So we're going to dispel this nonsense. We have a murder weapon. You want to scream in chat that we don't have a murder weapon because we don't have a bullet match? Fine. Be dumb. Go for it. I don't care. It's fine. People disagree with me all the time. You don't offend me. It doesn't hurt me. That's not a booger. It's my mustache. It catches light there. It's just how it is. It's just how the lighting is in here. I don't know what it is. I'm going to get arrested again. So we're going to do away with these dumb qualifiers like bullets do weird things. And, we might have a murder weapon. We might have we have a murder weapon. The bullet did not act in a weird way. Security didn't do anything weird. Paving over the crime scene isn't weird. None of this is weird. It's all very, very normal. It's all fully predictable. It's fully understandable if you take a minute and think, and you don't just listen to someone say, there were 12 Israeli phones on the ground. What does that mean? It doesn't mean shit. First of all, now that statement is contested. It also doesn't matter if there's Israeli phones on a fucking college campus. There's probably Israeli students. What about the 12 Israeli phones makes them special? Only if you assume that Jews murdered Charlie Kirk. Then you're like, aha, 12 Israeli phones. We don't know anything about these phones, who they belong to, if there's an explanation or not. We don't know anything about it. We just know that Candace Owens says someone said it. And the person who she says said it said, no, I didn't say that. So we're going to dispel this shit. None of this is weird. This case is actually normal. This case is actually straightforward. The evidence in this case is overwhelming. To overwhelm means to go beyond mere whelming, right? You go over it. Whelming means to meet an expectation. Overwhelming means to exceedingly surpass meeting the expectation. Throw away Andrew Wilson's weird definition of like, oh, it just satisfies me. Well, a lot of things satisfy me and I'm not overwhelmed by it. Satisfied is not overwhelmed. It's whelmed. But that's fine. He was setting the tone of the debate. I don't think he was trying to argue what the lexicon definition of overwhelmed is. But we're going to dispel this notion because it is overwhelming in this case. This case is about as straightforward and open and shut as you could hope going into a murder trial. They've got mountains of evidence. We're going to use the expressions just to piss people off, but they have it. The problem is people either don't understand what evidence is, they don't understand what evidence means, they don't understand what reasonable doubt is, they don't understand what doubt is, actually. They don't understand what speculation is. We know that Candace Owens doesn't understand what an inference is. Most of the things that people have said are weird are only weird because the people hearing them have never had to think through it before. They've never had to figure out if this could happen. So they go, well, that's weird. That doesn't make it weird. That doesn't make it weird at all. And I would contest most of it is not only not weird, it's expected. It's expected. Private security failing to protect the principal happens a lot. A whole lot. Probably a dark secret of the private security industry. But the reason that private security works and is worth it, even though they failed bad, he didn't live. Not even close. But the reason private security works is because having them there is a deterrent to many of the threats that might manifest otherwise. It's security theater, but it's effective security theater. It does its job. Having a bunch of dudes in black suits with a little bulge right here in their chest holster, they didn't all have mastectomies. So we know that's not one big titty with a small titty on the other side. We know that that's a gun. Seeing that keeps people honest. And I would contend that the security, VIP security for Charlie Kirk on that day did a threat assessment. The threat assessment found nothing online, no manifestos, no weirdos, no chatter. Charlie worried that the left is going to try and kill him. And they thought the most likely thing for Charlie Kirk, who invites people up to getting somewhat close range to him is that he would be in some way assaulted up close. A handgun, by the way, the most common murder weapon in the United States is a handgun. The most likely way Charlie Kirk was going to die that day would be a handgun. Of an intentional homicide, right? Not like an accidental death. Most likely way is a cheeseburger, but a handgun is the most likely intentional way that Charlie Kirk was going to be killed that day. A rifle's really low on the list, down with hammers. Charlie Kirk had 11 guys, 11 security agents there that day, according to the text messages. What were they supposed to do? It's easy to say they should have been on the Losi building, right? Like that's where they should have been. All 11 of them, right? Waiting by the door. Tackle Tyler Robinson and beat him to death on the roof. Throw him off the edge and let everybody forget about him. Nobody cares. But that's hindsight. That's only because we know that's where the shooter was. I know. He wasn't there. He was actually another 150 yards back on a different building, way higher up or something. Who cares? There are a lot of rooftops in view of that pavilion. There are a lot of angles that could have shot Charlie Kirk. Not all of them, but you have something like a 220, 240 degree field of view that could see Charlie Kirk, depending on where you are. You have 11 guys. What are you going to do? They were close to Charlie Kirk. They were in proximity to him, from what I can tell. And they had a couple other people around. A bunch of failures happened that allowed this. Why is the access to the roofs even open that day? Like, how did he get out there? Those should have been locked up by campus security, etc. But hey, all of those failures amounted in one dead guy. But you know what? That would have happened anywhere. If someone just decided to kill Charlie Kirk earlier, they would have. Because private security is not great at keeping people from dying. What keeps people from dying is typically luck. If you're going to get shot, you hope it misses everything. You hope it goes clean through and misses your major organs. That's your best chance. That's your best chance to live. It happened to Reagan. Well, I mean, I think Reagan he had some rough times, but like the assassination attempts that fail tend to fail because the person happens to live through it. Not because of the heroic efforts of the security agents. They act heroically after the principal is shot because they can't know he's going to get shot beforehand. They're not Kevin fucking Costner. Private security is not great. But it does stop a lot of attacks that would otherwise happen. And hold on, just gotta make sure. The most important thing is it stops non-fatal attacks. It stops assaults. It stops the throwing of cum or excrement on someone or piss. It stops a spray paint or a pepper spray. It stops these types of really annoying assaults, but they're not lethal. They're not lethal. Preparing for a lethal attack with no indication of what it might be, who it might come from, or where, or when, is impossible. See, look, we're going to address a retarded person right now. Good security would have had people on those roofs. You know how many roofs there are? In view of Charlie Kirk, there's like 9. You only say that because the shot came from the roof. If it came from anywhere else, they would have been wrong. The farther away you are from the principal, the less effective you are at being security. Valhalla is actually backing me up here. I know he is because I'm right. And Valhalla is smart. You can't just say, oh, well, yes, they should have had people on the roofs, but we only can say that because the shot came from the roof. If they had put 9 people up on different roofs, right, to all look down at the crowd and someone rushed Charlie Kirk, then they would have failed. They don't have a counter sniper team, right? This isn't the FBI negotiating a hostage situation in a Hollywood movie. They don't have someone sitting on a high perch ready to take out someone running across a roof. They don't have that. Like, this is a guy talking at a college. Also, security made their predictions and calculations based on 900 people showing up that day. But over 3,000 people showed up that day. They were already overwhelmed. But they weren't really overwhelmed because security isn't overwhelmed unless something happens. And the thing that happened instantly. There's no stopping it. There wasn't a follow-up. Like, if Charlie Kirk had been winged, right? Or hit in like a low stomach or something, tore through a kidney. So he's really like in bad shape. You got to get him to a hospital so he doesn't die, but he's not dead. And then they don't get him into the SUV or whatever. Then they fucked up. Then they did the worst job ever. But they weren't saving that guy. I saw it. His head lolled to the side like Stephen Hawking on a water slide, man. What were they going to do? He was done. He was done immediately. But they did. Here's the crazy thing. They actually did exactly what they were supposed to do in the instance that happened. Once he's shot, they don't know he's going to die. I mean, you can guess, but that's not what their focus is. They know that a shot rang out, their principal's down, they got to get him out of there. And they grab him and they put him in an SUV. People are critical. Dumb people are critical. They're like, well, it's weird because like 2 medical staff, 2 EMTs come trotting up and they're like, hey, let's see what happened. Maybe we can help. If those security guards had let those EMTs within a meter of Charlie Kirk, they should be executed because they don't know those EMTs unless it's their guys, which obviously it's not. They don't know those guys. They just had their principal assassinated or at least attempted assassination. They don't know if these guys are coming to finish the job. Their job is to get him to where they know the right people are, which is the hospital, the closest hospital. They put him in the SUV and they take him there. Anybody who says that that's weird or the wrong thing hasn't thought about it, or they don't know. They have no idea how this works. But why would they? Why would they have to do that? They don't need to. They don't need private security. They don't work private security. All they're doing is reading about something online saying, well, that seems weird. Well, yeah, it seems weird because you don't know. But if they had let those EMTs come up, what if those EMTs just had a fucking silence 44? Bam, done. I mean, obviously there'd be a reaction, but you don't know who it is. Remember, we only know that it was Tyler Robinson because it was. But all these people who think that they should have let the EMTs come up similarly think that this is a global conspiracy run by Jewish elite military. I guess if the EMTs came up and said shalom, they would have let them up, right? Like they would have let them in. No, you guys can fix it probably. You guys are all doctors, aren't you? Nonsense. Security didn't act weird. They failed. They failed their job. And you can say they did a bad job. Absolutely. You can say they did a bad job. You may be right, but it doesn't matter, does it? Because there is not a predictable way they could have done a good job. Not a predictable way they could have done a good job. And that's an important thing to remember. What does that do? Does that excuse anything? Does it tell us anything about the case? All it tells us is that this is not weird. Because weirdness, strange events, That's the weapon of the conspiracist. The weirdness is what is the tool. Oh, well, this is strange. Therefore, something else happened. But it isn't strange. And we need to start dispelling the notion that this is strange. You know who doesn't think this is strange? The prosecutors. Prosecutors are so damn confident in their case. We're about to start the document. I know. I'm doing a bad job. We're about to start their document. The prosecutors are so damn confident in their case. They're like looking around going, the fuck are these dummies talking about? They're about to annihilate the defense in court. They know it. They know it. And they also know the defense isn't really going to defend Tyler Robinson, which is not weird either. That doesn't mean the defense is in on it. The defense's job is just different than what you think it is. If you think them not defending him on the murder is weird, I got news for you. Most of the time, a defense attorney is not defending their client on the murder. Believe it or not, they're negotiating out. They're negotiating out a plea that keeps their guy off death row or with a chance of parole. Hey, let's knock this down to murder 3 or whatever. Like, Utah doesn't have murder 3, I don't think. It's irrelevant. No, let's knock it down. Let's mitigate some of the sentencing. Let's show you why, like, our client was in a bad spot. He's not really a danger, et cetera, et cetera. That's what they're fighting. They're not fighting the murder. A lot of times they're not fighting the murder because their guy did it. Tyler Robinson did it. The defense knows that he did it. They don't know because Jews told them. They know because probably he told them, or he gave them enough information for them to know. But even if Tyler Robinson didn't say a word to his defense attorneys, and they're like, all right, we're going to defend this guy. He's good. He's not even talking to us. And they showed up to the pretrial hearing and saw what they saw. They'd look at him and be like, you're fucked. What are you doing? You don't have a chance. And the only way you get around that, the only proper analysis let me rephrase that. The only analysis that says something other than that this case most likely is going to result in a conviction, probably the death penalty. The only analysis opposed to that is one that doesn't make any sense. It's one that doesn't have the facts. It's one that isn't looking at the evidence properly or maybe completely, or is just unaware in any way of how a murder trial is going to go. This case is not close. The prosecution is going to tell us how not close it is. But I do have to say something. I'm going to read the super chats. But I do have to say something. Some people have noticed, and thank you for noticing. I am a fully licensed attorney again. So I am 100% authorized to practice law. I was dumb a couple days ago. I was stupid and I didn't know what I'm talking about. But now I do, because now I'm a licensed attorney. And so now all my opinions are correct. So I'm sorry for having incorrect opinions for so long. They were all wrong. But now I'm right. You can't stop me. Finally, now everybody's opinions about me will change. As I've stated the whole time, the only reason I was suspended had nothing to do with discipline. I've seen some theories. People are like, aha, he let his license lapse so he could avoid other discipline. Nope. No. Nothing like that. Also, if my license was lapsed, they could still discipline me. You don't stop just because your license is suspended and you're not active. You don't stop being under the authority of the Lawyer's Professional Responsibility Board. So that was a dumb theory from some people. It's not true, but it is funny. But no, all I had to do was my CLEs, which Took a minute. It took a minute to do, but that's where I've been the past kind of 2 weeks. I haven't been around as much because I was grinding really hard on that. I had the opportunity to do so, and I did. But I'm now fully licensed attorney, which is it's really just vanity, I guess. I don't really practice law very much. I like doing this instead. And this takes a lot of time, and it makes it hard to do the other stuff. But that said, thank you for the wonderful congrats. If you want to buy me a present, I take gift cards to Sizzler. Just kidding. Please don't do that. Don't do that to anybody. All right, here we go. Gambling Rambler sent a goat trophy. Fletcher Boy says unsuspended Mazel Tov. It's correct. That is accurate. Wild Critter says clean your dirty lenses, you filthy bum. No, now they're worse. That was dumb. See, sometimes my defiance gets me in trouble. Pilot Grove sent some jewels. Appreciated. Lurch Linger gifted a membership. And guys, we are right about to have a member show. I've got some juicy rotund lawyer content for you. Full on autism engaged. It's going to be great. That's coming maybe tomorrow. It was supposed to be earlier, but something came up. Heather Whitaker, member for 21 months, says congrats on the unsuspension. Thank you. Knitting Kitten says someone should run Candace and Andrew's debate through AI and turn it into a gospel rap song. Oh God, that'd be forever. Seize the days. The lady trying to take your life lost hers. Romans 12:19. Gen X Medic. Remember the guy Kyle Rittenhouse disarmed was a paramedic, but he knew not to talk to cops. Another thing to remember about this is you will never convince everybody, no matter how good your evidence is, no matter what, right? I think it was Kevin Hart was talking about Kyle Rittenhouse like 2 years after the event, after he was found not guilty. And Kevin Hart, he was talking about it somewhere, and he still thought at the time that Kyle Rittenhouse shot black people. Like, no, he missed the black guy, right? Because it was dark out. Right on Gals and some jewels. Hey, what's up? Thank you. Thank you. D74715 says, I'm a genius, but I disagree with you in Valhalla. Am I still a genius? No. Just kidding. Glad to see you streaming. Keep it up, brother. Hey, thank you. Thank you. We got Stephanie, member for 8 months, says congratulations. Very much appreciated. That's a lovely member you have. D74715 says, my man, you must have hit up those Clio CLEs. Now, Minnesota CLE. God, it was a lot. It was a lot. Pastor Flash says just moderately pretty. Oh, Ops says pretty. Oh, no, he said moderately petty. Oh, Oops says pretty. Yes. Yeah, I'm very petty. We've got Edith Medick over on Super Tips. Oh, shit. Hold on. Hold on. I have the audio going through the wrong thing. That's my bad. I'm fixing it right now. Okay.
Tool mark analysis is a forensic discipline that identifies the specific tool responsible for impressions, cuts, or abrasions found at crime scenes, such as those on doors, safes, or wires. Examiners evaluate both class characteristics, which narrow down the tool type, and individual characteristics, which can link a mark to a specific tool.
My birthday was Saturday. Can I get a toast?
John's dead.
A big toast to Edith Medick. Met you in Vegas. Had a good time. Really cool. Hope to see you next year. Or hope to see you in Atlantic City, assuming I head off to that, which I believe I will. But happy birthday, man. to many, many more. And may you never be shot in the neck by a gay weirdo. That's my first straw toast ever. That was weird. That was very uncomfortable. Scarlet's Mind, member for 2 months, says shout out to Chaos B / the other Mary B. Big shout out to them. Well, Mary B. Is that the same person? The other Mary B? Or is Chaos B a separate person? The other Mary B is cool as fuck. Raggedy Man says, well done, Nick. Thank you. John H. Member for 10 months says showing you an impressive one too. I'm very happy to see it. Thank you. Made my whole day. Let's see. We've got a couple Rumble rants as well. VSync says, fascinating about Data Republicans outing as actual Fed poster today. Her first tweet storm on Hegseth's payroll was lambasting Candace. Recap and digging in after my market stream and after yours ends. Well, there's a good reason to lambast Candace Owens. I think this is important to remember. It just, the government sucks. But some people suck worse. They really do. Candace Owens is one of those people. She's fucking awful. An absolute menace. So I got a quick thing. So this weekend, I was gone this weekend with Lady Rackets. We go to an art event every year, right? We go to an art event every year. It's really cool. I'm not going to sit here and bother you guys. I'm like, it's cool for us. It's cool that we get to go. I'm not going to sit here and like tell you about it, try and convince you or anything. I've talked about it in the past, but I posted a picture of it today, or like a picture of us today up on Instagram if you want to check us out. It's a great event. Like for us, we get to dress to the nines and we like it. It's enjoyable. But that's where I was all weekend. Where was I going with this? Oh, yes. So the person who invites us every year, who I love very dearly, is a Candace Owens fan. And it made conversations a little bit tough because they're like, oh, you like Candace Owens, right? And I'm like, no, not at all. I don't think she has any credibility. But, it didn't matter. We had a nice time and all over laughs and smiles. But Candace Owens is out there. Like she's all over the place. I read over the weekend that she, in the wake of the Charlie Kirk killing, she has grown to have the biggest podcast in the world. Think about that. Candace Owens has the biggest podcast in the world. And she's the primary source for most people on the planet for what happened to Charlie Kirk. That's a crime. That's a crime. Oh, hey, what's up? There's the other Mary B. How you doing? Nice to see you. I don't mean that should be an actual crime. Like, I don't know it's not Candace's fault. I don't know who you'd even charge on that, but it's insane to think about that the primary source for people on Charlie Kirk is Candace Owens, the #1 in the world. And on a bunch of other subjects. This is awful. But this, though, importantly, this involves Candace Owens. Like, commentary necessarily involves Candace Owens because she's such a big figure in the overall zeitgeist, right? But this isn't about Candace Owens. This isn't about proving Candace Owens wrong. This isn't about going after her or cutting her down. Who cares? If she's got the biggest podcast in the world, great. Good job. This is about the truth. This is about the reality of the practice and exercise of law. This is the reality of trial in the United States and our criminal justice system. Candace Owens is a side character in that. She's incidental. She would probably call it an inference because she's retarded. But that's one of the defenses that comes up all the time is, why are you attacking Candace? Nobody's fucking attacking Candace. Candace is incidental to all of this. She happens to coexist in the space. Again, she would call that an inference because she doesn't know. But it isn't about attacking her. This is about helping people understand the system for realsies, not for pretend. Unfortunately, lots of pretending going on. The other unfortunate thing is, of course, a side character to that is Baron Coleman, and to a lesser extent, Lionel Media. Those two guys are lawyers. That doesn't make them correct in any way. In fact, it makes it more offensive at how incorrect they are. But these are the people that are leading the information crusade. I get a lot of comments saying, I watched you through Rittenhouse and Depp, blah, blah, blah. And what happened to you? Nothing. Well, I mean, some stuff, but nothing happened to the analysis and the opinion. My approach wouldn't have been different 4 years ago than it is now. The only thing that changed was people. Well, I don't think it was changed. It didn't change. The only thing that became apparent is that people liked my analysis because it agreed with what they thought. And I knew that. I knew that on Kyle Rittenhouse. I knew that on Johnny Depp. I knew the pulse. I know the pulse on this case too. I didn't pick my opinions in Kyle Rittenhouse and Johnny Depp based on the pulse of the country. It's just what it was. It's just the right thing. Kyle did not commit a crime that day. He didn't. You could see it from the moment I watched the first video when it happened. Started talking about it immediately. Never changed my opinion. State never presented anything even close to a murder case there. But that wasn't because it was popular. That's just because that's what was right. Johnny Depp, same thing. Johnny Depp is not a superhero. Many accounts, he's not the best. I mean, I don't want to say he's not the best actor. I don't mean like professionally. He's one of the best actors. But he's not the best person doing the act, right? He makes bad decisions a lot of times. So what? He's not supposed to be a hero. But the reason I supported Johnny Depp is because it was obvious. It was obvious what was going on. Amber Heard was weaponizing Me Too in the legal system against Johnny Depp. That was the whole thing. And everybody was falling for it. All of Hollywood fell for it because they were so scared of women. That's what happens when you take Weinstein out. When you get Weinstein out of Hollywood, suddenly you're scared of all the women. He was keeping him in line. That was awful. That was offensive. You can be mad about that. You shouldn't be, but you can be mad about that. But I was on Johnny Depp's side because it was right. I'm on the state's side in this case because it's right. Because Tyler Robinson is the killer. Because the state has already shown us so convincingly that he's the killer that it's ridiculous. We normally don't get this in a full trial. We've already got it. The people trying to convince you otherwise are dumb or lying. That's it. There's no bones. There's nothing about it. The people who are most invested in Tyler Robinson's defense are acting like he's guilty. And you know who that is? Tyler Robinson and his defense team. All of those people are acting like he's guilty. The people shouting into the ether that he's not guilty, that it's some Fed setup or whatever. Those people have no skin in the game and they don't have any brain cells left. What they have is some sort of internal desire to deliver this message. I don't know if it's money. I don't know if it's influence. I don't know if they're just convinced of their correctness and it's that conviction, and it's fine. It's good to have conviction. It's good to be confident in your assertions. That's fantastic. You can still be fucking wrong though, and they are repeatedly. Some of these people though, I'm going to put the laser focus on Baron Coleman here because most of the other cast are like observably retarded. Sub-Saharan IQs, like embarrassing levels of intelligence going on. But Baron is a licensed practicing attorney who's been practicing for a very long time, and he wears hoodies. So obviously he should have correct opinions, but he's wrong. And I don't think he's wrong. Well, based on the quality of legal work I've seen from him, okay, maybe he is wrong because maybe he's just wrong. That's okay. But Baron Coleman puts forth this like anti-state message and all this stuff, but he worked for the state. He was an informant. He was an informant for the prosecution. That's a whole other thing. We'll get into that at some point. But this isn't about them. This is about the truth. That's why I'm talking about this. And let me be very clear. Let me be very clear. My motivations in this. Yeah, I care about the truth. Yes, I care about correcting people on improper legal analysis and all that stuff. But I like money, and I like views, and I like being correct, and I like influence, and I want all of those things. This is a good case that people are interested in. I want them to come watch my show. I want them to pay me. That's what I want to happen. But that doesn't mean I'm not correct. And that doesn't mean I'm selling you some sort of lie. I'm not. I'm telling you stuff that is consistent with the analysis I've done from the start. And by the way, I've always been motivated by the same stuff. You know why? Because it's fun. It's fun to do a job and to get paid for it and to be like to have fun while doing it. I get to do all those things. It's great. So there's my dark motivation for everything. That's what moves me. I know I get like accused of being a Fed and all this stuff. People obviously don't know anything about my situation. That's fine. But the reality is very simple. I like analyzing cases that are interesting. And when you have dumb people who are like out there getting a lot of attention, it's fun to shit on their stupidity. It really is. And I get to educate people about the legal process, and I get to learn a lot too. So I like all of this stuff. You know how it goes. This is YouTube. Anybody not trying to make money just has a hobby, and that's cool. Kaufman says, here is 10 Jew dollars for your next Sizzler dinner. No, now I have to use it for that. Rob Price, 61 months of membership. Oh my God, it's beautiful. It's not like Charlie could afford BlackRock or Vanguard for security. Also, they didn't have a 20K surveillance drone watching for people on roofs. Please tell me you've learned Mauser is an action, not a rifle. I don't know. It's a Mauser rifle. Like they call it a Mauser rifle. I don't care. You know what I'm talking about. That's what matters. Tyler Robinson's grandpa's penis shooter. There. That's what it is. That's, you know what I'm talking about. You know what the gun is. That's what we need to happen. Pendar, remember for 18 months says practice law on the Rivervale server. Wait, are you saying on EverQuest? Oh man. I like EverQuest Legends. It's fun. Official Chris Tony sent some gold coins. Thank you. Some shekels. I appreciate it. Okay. Emorsk says, with modern machining, you cannot match a bullet to a gun unless there is a defect. You can only match to a type of model in a series run. Been that way for the last 100 years or so. Well, that's cool. This gun is really fucking old though, so it doesn't follow those rules, right? This is a 100-year-old gun. K to the Swiss sent nothing. But thank you. Cat Slave says, congratulations. Numero uno Josh Denny fan says, are every pair of sunglasses you own cheap, retarded, and generally bad looking? Yes. Are you joining in with the other streams and giving all donations today to Ice Dancer, or do you stand with Mersh? No, neither. I'm not getting involved in that. I don't care. And why would I do that? Good Logic has rated the stream. What's up, my man? Good Logic was here just in time for the talk about Israel. He always comes in. If Good Logic always shows up when I'm telling very lighthearted jokes about Israeli people, usually Zionists specifically, does that mean that he is Mossad and like he gets a bat signal? So he shows up to keep me in line? Or is it just that I'm always doing that? And so it's just bound to happen. What's up, my friend? Good to see you. Thank you so much. Uzelian says, goodbye, Jews. Joey B says, I found you during Kyle's case, lost you for a while. Cocaine, apparently. It was apparent. It was apparent. You are fantastic. Thank you for what you do from the bottom of my heart. Oh, thank you, Joey B. I appreciate that. Mephisto says, no, I'm the Mossad. You forgot. I didn't forget. I think I'm important enough for two of you.
Kirk met Candace at a bar and she threw her drink in his face. He was like, bitch, there was like $20 war for roofies in that drink.
Oh, no, don't roofie anybody. Don't do that. Okay. Mr. Mike says Candace is not the biggest podcast in the world. Okay, that's what the article said. Take it up with them. I don't fucking care. Maybe it was in the US. Who cares? She's still the biggest source of information about Charlie Kirk for people. So, aha. Take that. All right. Here we go. We need to go to, let's pull up this response or reply, the reply brief for the state of Utah against Tyler Robinson. I like this reply brief because, some of the stuff we've seen in Utah is very reserved, and people are like, yeah, it's like the Mormon culture, like has a lot of influence, etc. And that's kind of boring. So, so you never know kind of what to expect. You never know what's actually going to happen. And in this case, what happens is they don't act like that at all. Again, I think the defense really pissed off the prosecution in this case. I think so. Let's see. Oh, here we go.
I love LawTube simply because you all want to be right.
Here's the problem. I'm not LawTube. Never was, never will be. Some of my very good friends are in LawTube. I have LawTube friends. I'm not racist. I have LawTube friends, like one of them or whatever. But I'm not. And here's why. They want to be right. I am right. I am correct. Also, I didn't lie about getting a haircut. No one mentioned this that I've seen, but I went to go get the haircut and I was late. So I have to wait. I had to wait to get it. Okay, here we go. So this is the reply memorandum in support of preliminary hearing bind over. Oh, one other thing I'm going to do, because this, I don't know if anybody's done this, but we need to start doing some of this stuff. We're going to go through, or I might do these live, but ultimately they're going to be independent videos of each warrant request. Each warrant request, because the warrant requests, one, they contain a bunch of information that isn't necessarily, that hasn't been presented at the preliminary hearing. They contain information about how the cops justified their warrant requests, right? Like they have a probable cause statement on each one. And they also give us a clue as to what evidence might be out there. And I think a lot of people are missing that. And they don't realize, like, I don't know if people understand. Tyler Robinson GPS'd. He created a Google GPS route from where the rifle was found. From the GPS coordinates, because it's not an address. It's just a spot on the side of the road, right? In the woods. He created a map from that spot to his house and drove there at 1:13 a.m. After he failed to retrieve the rifle. He went right to where it was. He was no longer there. And then he GPS'd home. And the cops know this. They've seen it. It was part of the basis for the probable cause to search further. The evidence People are misunderstanding what evidence is. The evidence that this gun is the murder weapon is overwhelming. It's overwhelming. It's not even close. Here's the other thing. And I know, and I'm going to say this until I die, which may not be that long, honest. Like, who knows? People don't understand what evidence is. Evidence is anything that makes a fact more likely to be true or less likely to be true. That's evidence. That's evidence. Now, evidence has to meet a relevance threshold, and its probative value must outweigh its prejudicial impact. So they can't introduce me making a statement of that gun is the murder weapon Tyler Robinson used to kill Charlie Kirk. However, if we assess that statement, it is, in a general sense, it is evidence. Me saying it makes it more likely to be true. But then we get to the balancing test. That's a prejudicial statement against Tyler Robinson, and its probative value is very low because I'm not an investigator. I'm just a guy on YouTube, right? As far as you know. But it is still evidence that makes it more likely to be true. Some would say less likely to be true, but more likely to be true that is the murder weapon. It does. Just it's such an infinitely small amount that it's worthless. Like, it's not worth anything really, but it is probative because I said it. Now someone can think it. Now it's more likely to be true. It's an expression of belief, but it's an irrelevant expression of belief in the grand scheme of things because I'm not tied to this case or whatever. So its prejudicial impact, which would also be small, it outweighs its probative value. So it's not admissible. It's not useful. But just the point in this is a statement is evidence. That's what testimony is. Testimony is evidence. Statements made by Tyler Robinson are evidence. The circumstances of the finding of this gun are evidence. The fact that the gun is 260 miles away from home, like, that gun is out late, past curfew. That's evidence that it's the murder weapon. It's really good evidence because what the fuck is it doing there? The other, they say absence of evidence is not evidence of absence. That's bullshit. That's scientific, okay? In a murder trial, evidence of absence is, or like absence of evidence is evidence of absence. And this is critical on the gun. There isn't another gun. There's no indication of another 30-06. Everybody's bitching and whining about like, this gun's too big. Like, he was carrying around a big gun in his pants, right? Like, it's too big. How did he do it? It's improbable that it was up on the roof. We know it's on the roof. We watch him drop it down. They have a theory about how he got it up there. They could be wrong on that theory. That gun is on the roof. He shoots it, and then he carries it to the edge of the roof, drops it down like a child, drops himself down like a ninja, picks up the gun and runs off and drops it off in the woods. We know that happened because it happened. It's on video, and they found the gun where it was supposed to be. So we know the gun was on the roof. Everybody says, oh, there's no video of the gun on the roof. There fucking is. There absolutely is. They might be wrong about him bringing the gun up in his pants. I don't know. Who knows? Doesn't he have a backpack on too? Like, I'm not sure. It doesn't really matter though, because we know the gun gets on the roof. They have a theory about how. If you disprove it and the jury goes, well, that's not a gun in his pants, he's just happy to see me, I guess he didn't do it. Okay, then he's not guilty because the jury says so. That's fine. But there's tons of evidence that that gun's on the roof. There's no other gun. None. There's no other gun. There's no other bullet. There's no other casing. There's no other anything. There is an absence of any evidence at all. And that is evidence of absence, especially when you consider how big this rifle is. Where's the other shooter? Where's he able to? Or she? Probably not. Would have missed. Just kidding. Women are apparently really good at shooting stuff. I don't know. Where are they, them? Where are they carrying the gun? How'd they, them avoid all the cameras and witnesses and everything? How'd that happen? We still need a .30 caliber rifle. It still has to shoot Charlie Kirk and kill him. That still has to happen because it did happen. I know this case is a collapsing catastrophe for the narrative that it was anybody other than Tyler Robinson. If you really go back, these dumb motherfuckers swore up and down that an autopsy not only didn't happen, but was impossible. They swore it the day before the prosecution filed their first brief and quoted the medical examiner's report. The day before that happened, Baron Coleman was insisting that an autopsy was impossible. So is Candace Owens. The body hadn't been refrigerated. They didn't have time to cool it down because they're dumb. They're like, you got to cool down a body to do an autopsy. No, you have to cool down a body when you're not going to do an autopsy. That's the only time. But that, again, this is because they're idiots. They swore that. They like to sweep that under the rug because they got blown out. They got blown out on that one the next day. These people are catastrophes of reasoning, of logic, of understanding, and of conveying messages. They aren't conveying truth. They've routinely been embarrassed, but they're not embarrassed. They steamroll past it. They learned how to do that. They don't have anything to apologize for because it's not that they're like, Candace is like, if I'm wrong, I just say I'm wrong. No, you don't. You're wrong all the time. But Candace is convinced of her own correctness and unable to be taught because she's dumb. So going back to that, she's never wrong. She said she would claim that she was wrong in the debate with Andrew Wilson. Didn't do so, but then claimed that she did. She was wrong about admitting to being wrong in the same fucking sentence. These people should not be guiding anybody's opinion. And I don't mean that they should be stopped or anything. I just mean that they don't measure up. They don't measure up on any of these claims. All of their claims are ludicrous, and it's based so obviously on either a genuine misunderstanding or genuine dishonesty. But it's never based on them being correct. It's amazing. Anyway, hold on.
LawTube is not something you get to accept or reject like the word gay.
Yes, it is.
Well, Mr. CLEs don't hate love. Let Charlie be a light beaming in the tinfoil hat society. You wouldn't go in the ring to take a shit, Mike TJK. But seriously, we're proud of you, counselor.
Thank you. I'm proud of you guys too. All right, here we go. Because when you're proud of me, you're correct. And I love it when you guys are correct. All right, let's do it. Let's do it. So this is the introduction. This is, again, the reply memorandum in support of preliminary hearing bind over. Defendant does not challenge the substance of the evidence, demonstrating that he was the person who crawled to the sniper's perch on the Losi building rooftop, fired the fatal shot that killed Mr. Charlie Kirk, hid the rifle in a wooded area, got rid of some of the clothing he was wearing, and told his roommate to delete their texts about the shooting. They don't dispute that at all. Not once in their preliminary hearing. They have a general statement saying, yeah, they didn't do a good job. And that's it. Rather, he merely asserts, he being Tyler, he merely asserts the repeatedly rejected claim that the overwhelming evidence establishing some of these facts could not be introduced as reliable hearsay at the preliminary hearing. Defendant therefore raises no valid challenge to the evidence supporting count one at least murder. By the way, do you think the prosecution isn't watching? You think the prosecution isn't watching the commentary about this? Maybe just on Twitter. Who knows like what they're watching? But listen, look at this sentence. We have overwhelming evidence. That's a big fuck you to Candace Owens, to Baron Coleman. That's the state saying we have the overwhelming evidence. Fuck you. This also. Count one as at least murder. What does that sound like? We charged him with murder, you fucking dummies. He is charged with murder. Candace Owens was so blatantly incorrect on that. It's frustrating that Andrew Wilson didn't possess the requisite lexicon to deal, like, he doesn't speak the language of law. Maybe the language of love, I don't know. But he doesn't speak the language of law. So he wasn't able to, in the moment, say, no, listen, you don't understand. Murder's a lesser included offense. He is charged with murder. But give me just a second. It's aggravated murder. I know. But we're just talking. He didn't have an opportunity, or he didn't really take the opportunity to do that in the moment. So Candace capitalized on it. But all Candace did was hold up a giant pennant that says, I'm fucking stupid, and run around in a circle on the internet. And she was jerked off by a bunch of sycophantic people who believe what she says because they are also, we'll say ignorant to be polite. Ignorant. They're also ignorant. He was charged with murder. Murder is part of aggravated murder. The prosecution is rubbing that in all of their faces. Of course they are. They're doing so because this argument is really stupid. Of course he's charged with murder. I don't think that's a mistake. I think that's a big fuck you. Count 2, felony discharge of a firearm causing serious bodily injury. Counts 3 and 4, obstruction of justice, or count 5, tampering with a witness. Hold on. We need a little bit more mic cable here or something. It's too tight. Come on now. What the fuck is going on? Okay, there we go. All right. Jonathan says rifle was on his back, pack over the butt, and the barrel down his pants and butt crack would explain that odd walk. Tyler Robinson was readjusting it. Well, either that or he had to tape his dick to his ankle, right? Like something's going on. Something is wrong with this picture. I walk like such a fag. Bitter sweetheart. Member for 9 months says, it's a law, baby. Oh, 9 months. Happy reinstatement. We love you. Oh, I love you back. Thank you. Tawa and Z sent some jewels. Appreciate that. Joji, member for 9 months. Very nice. Rackets is the queen of LawTube. Correct. That's true. Mavericks Cubist says Andrew Wilson didn't give enough fuck to look at the case. That's why he looks so bad. That's nonsense. He's just a hired gun for TPUSE and the Zeos. You can think that all you want. I don't really care if he is or not. But saying he didn't look into the case is nonsensical. He made more cogent points about the case than Candace did. The only place Candace won, she was wrong. And that was on the charge. She got overly pedantic on the charge. And Lamau, it's an internet debate, so who fucking cares? It's funny. She won by being funny. But that's literally the only point in the entire debate that in any way went in her favor. Everything else was Andrew Wilson lecturing her, even though she spoke almost twice as much as him. Woman. But to say he didn't look into the case is silly. He knew plenty of facts about the case. He was imprecise on one irrelevant item, which is aggravated murder. Notice what Candace did. Well, I wanted to talk to you about aggravated murder, but if you don't know that it's called aggravated murder, how can I? Candace, you just sat and for 2 hours talked to someone about subjects you have no knowledge of. He educated you. You could have educated him on aggravated murder. I think he already knew about it. He just didn't say it in the moment, but I ultimately don't care. I don't like Andrew Wilson. I don't have any hate for the guy, but he's not like my homie. Like, we're not buddies or whatever. I'm on his side on this in general, but not because like of our long-standing history of bro jobs or anything. That's beside the point. But he didn't look so bad. That's the weird thing. Candace looked awful, except for that one moment. And you know how we all know that that's true? Is because that's the only moment that you heard about in the entire debate from Candace Owens. The only thing that you heard from Candace Owens is her call him out on saying murder versus aggravated murder. But she didn't follow up by debating him on the aggravated murder. She said she was going to, but Candace Owens always said she's going to do something and then doesn't. She's an embarrassment. If I were a black person, and I am half black, if I were a black person, I would be ashamed. I would be ashamed. I would call her profane words. Maverick Cuba says, what will you say if Tyler is found innocent? I'll say that the jury found him innocent. I don't think that's going to happen. They can. Absolutely. I said over and over, right now, we should believe he's going to prison forever because the prosecution controls the narrative and controls the evidence for the most part at this point. We should feel like he's going to prison. He should look guilty. Even if he's not, he should look guilty. If he doesn't look guilty right now, the prosecution's not doing their job. It is nonsensical to think that after a probable cause hearing, someone looks not guilty. Why are we doing a case if they look not guilty? He looks guilty. The defense has a trial to challenge any narrative that they want or to raise their own competing narrative. Maybe they will. I don't think they're gonna. And right now, we have no reason to believe that they will. We have nothing. That could be because they're holding their cards close to their chest. From us, from the public, which doesn't make sense. It does not make sense to not defend Tyler Robinson publicly. If he is not guilty, if Tyler Robinson is actually not guilty, you should be defending him. His public image is at stake. If he's not guilty, he has to live after this. And a whole lot of people are going to believe he murdered Charlie Kirk, no matter what you do. So your job as a defense counsel is also to help with his public reputation. And they're not doing anything like that. The only thing they've done is present an argument mitigating the death penalty. And that's about it. Now they have time, of course, and they may do it at trial. But it's a strange thing because there's no restriction on the defense doing some things, challenging some narratives to make their client look a little bit better in public. I'm not saying they need to release a bunch of like evidence against the judge's orders or anything like that. It's some advocacy outside of the courtroom. A statement that our client maintains his innocence. That statement doesn't exist. Why not? Why not? That's the safest statement in the world. Tyler has not pled guilty yet. He might. But there's a reason why they haven't made a statement that he's maintaining his innocence. because he's probably already in negotiations to not maintain his innocence. Here's a misunderstanding. The prosecution in a trial often knows if someone did it or didn't do it before trial. They know what the defense's strategy is. They know what the defense's evidence is most of the time. Sometimes there's some surprises, but rare. They know he's guilty. The prosecution is not going to be surprised if Tyler Robinson says he's guilty. They're not going to be surprised if they win. They may be surprised if they lose because they know that he's guilty. In fact, they probably know that his defense believes he's guilty too. They're still going to go and fight, and the defense can raise all of the proper defenses. He's entitled to that. It's his goddamn right as a murdering American. But everybody knows. The people who don't know are the people out here. Like, in this case, it would do nothing of obvious harm for Tyler Robinson to maintain his innocence through a statement from the defense. Nothing. Unless they're negotiating with the prosecution, and that would piss the prosecution off. Because if the defense wants to negotiate with the prosecution for a plea deal, there is no way they can inflame the insane conspiracy crowd. Because I'm going to tell you, and I am not putting this on the conspiracy theorists. I am not. I don't believe in this. This is not my opinion. However, this is reality. Those prosecutors are looking at the crazy people like Diligent Denizen, Stu Peters, Lionel Media. They're looking at not them specifically, but they're looking at the crazy people who watch them. If the defense riles up the insane people, every one of those prosecutors and the defense attorneys, they all know their lives are immediately at risk. And this isn't like a joke. This isn't a hyperbolic statement or whatever. This is not true in every case. This is a major case. You get some fucking whack job who fully believes that Tyler Robinson is not guilty because Candace Owens and Baron Coleman convinced him of that. And then he takes the extra step. This is not their fault. This is 100% not Candace or Baron's fault. And I am not accusing them. I never would. I've been accused of this. It's not true. They're just doing their thing. They're not inciting people to this. But crazy people are crazy. And when you have enough numbers, you have a high enough chance that a crazy person becomes a real possibility. And that crazy person might be fighting for the innocence of Tyler Robinson hard enough to murder somebody. And that's not a joke. And again, it is not any commentator's fault. They should all full-throatedly voice their opinions. None of them, I've seen nobody call for anything like that, and I will never accuse them of having that responsibility. They don't. They don't have that. What I'm saying is that the people who are doing the lawyering, they may not hold the same opinion I do. They may be looking at the conspiracy people going, they're going to rile up some fucking nut job and he's going to come in here with an AR and blast us all to pieces. That's a real fear. That's a real fear. When something gets large enough, the statistical likelihood of a crazy becomes higher, like obviously. So with that, there's no way the defense is going to rile up. There's no way they're going to rile up the public to Tyler's innocence if they're negotiating a plea deal, because the prosecutors will shut them fucking down immediately. Say, no, your boy's going to the death penalty. We're going to prosecute this to the maximum if they maintain his innocence. But they haven't done that. And that's why. You can call me wrong. I'm not. Nazar says, Barron's take said the introduction is tainted and abuse of the legal process. Of course, he blocked me asking hard questions. That's because Baron Coleman is retarded. This is not tainting in any way. Lick my taint, Baron. And it's certainly not abuse of the legal process. What an idiot. What a fucking dummy. Maverick Cuba says, Andrew Wilson couldn't remember 7 charges. How do you know? He only had the chance to say 1. But who cares? They weren't debating the 7 charges. They're not sitting there debating obstruction of justice. The question is, did he kill Charlie Kirk? That was the debate. They laid that out at the beginning. Instead, he had a secret special boy text that goes against what TPUSA has said prior. The text is irrelevant. The text was for clicks, obviously. Even if Tyler is guilty, TPUSA sunk the brand how they handled this. There was no saving TPUSA after Charlie died. TPUSA has to evolve into something new, or everybody has to get new jobs. They don't want to get new jobs. They want to try and carry on their friend's legacy, and they want to keep their jobs that paid them pretty well, I'm guessing. They're going to try and maintain it. They're probably going to fail. Charlie's not there. They need another Charlie. I don't know who that would be. Who's going to do it? Maverick Cuba says, why would the prosecution care about crazy online conspiracy theories if they were focusing on a court case? Because the crazy people might kill them, dummy. What do you think? What do you think? What are you talking about? Prosecutors get murdered. I don't know if you know this. Like, that happens. Prosecutors are more at risk of getting murdered if people believe they're prosecuting an innocent person. Facts are facts when it comes to court. Yeah, the prosecution is presenting facts. Defense is not. That's the thing. Why? I'm telling you why. Here's where you're going to run into an issue arguing with me on this subject. You're going to argue something that isn't happening. I'm not arguing with you. I'm telling you what's true and correct because I'm correct. The defense is not maintaining publicly Tyler's innocence because if they do, the prosecution won't deal with them very well on a plea agreement. 1 second. What's up? Yeah, I guess. No.
It's the worst movie ever. It's like animated, but it looks like it was animated by 13-year-olds in Flip-A-Clip. The villains, they're called white malians. Right? White men.
White malians are the villains. I love it. It's perfect. That's true.
It's the worst movie. It's so awesome. I want to watch it with you.
Yes, we will definitely. What is it? Never mind. Lesbian Space Princess. Okay. Bye. Love you. Good night. Okay. Okay. Sorry about that. All right. Oh, see, this is the thing. Nazar says, I would hire Nick Rekieta to replace Charlie. I couldn't do that. One, there's some history, right? Like, I don't think Charlie ever pounded a bunch of cocaine. Maybe he did. Maybe he did. Maybe he did. But I don't want to follow in the footsteps of an assassinated guy. If I wanted to be Charlie Kirk, right? Like I would do more live events like that. Like if I wanted to be him, I would do that, but I don't. I don't need to be hired by TPUSA to do something like that. You just start doing it. You go and you set it up. You set up a table at a college and you just start asking questions, right? People can follow the model. I don't want to do that. I've never wanted to do anything like that. I don't want to be punched, stabbed. I don't want to be like arrested because of some melee that brings. I don't want anything to do with any of that shit. I have a wife and kids to go home to. Charlie Kirk did too. Now he believed in his brand and message and everything to a point where he was confident in what he did and he was okay with the risks. I don't want that smoke. I really don't. I want to go home and not be dead. That's my goal. That's my goal. Right-wing extremist says if Tyler pleads out and we don't see the evidence laid out in court, they will say the fix is in and it will linger forever, linger more anyway. It's going to linger. Yeah. It's going to linger no matter what happens. There is no outcome that will satisfy the people who have been radicalized, and I don't mean that legitimately, but people who have been radicalized by the narrative. That's not going to happen. There's now a sunk cost fallacy. It's too important. It's critical. Charlie was so great. Half these people don't even never liked him in the first place.
The stupid talk chat is a pain in the ass. So much Candace got bored and starting yelling about murder nuances. So much for delineating degrees of murder is like delineating Nick on X or Coke. JK.
The answer was yes.
Just the fact it was a hearing and not a trial seemed to elude both of them.
Yeah. And again, Andrew wasn't there to speak law. Candace wasn't either, but she pretended to be at the end. Candace wasn't there to say anything. And maybe that was the smartest play in the book, right? Like she made $300K just by sitting there, being retarded. Ginger Puff says, the most the defense can do is try to get the death penalty off the table. They have not argued his innocence. Yeah. And they could try to argue his innocence, right? Like nothing's stopping them other than it's going to make the plea agreement really difficult if they tried to do that. And by the way, the prosecution's I think the prosecution's pissed off, at the defense. That's coming up. Okay, so here we go. Sorry, I talked way too much there. No valid challenge to the evidence supporting count 1, at least at murder. Count 2, felony discharge of a firearm causing serious bodily injury. Candace didn't know this count, by the way. Candace said this so improperly that it wasn't this crime or another crime that it could be, which is discharge of a deadly weapon. Candace said felony discharge of a weapon. That's not a crime. That's not a crime in Utah. There's felony discharge of a firearm with the enhancer of causing serious injury, or there's discharge of a deadly weapon, which presumably isn't always a felony, which is why it's not felony discharge of a deadly weapon. Candace got this count wrong. Her criticism of Andrew Wilson applies exactly the same here. She was completely wrong if he was wrong. Of course, neither of them were wrong. They were speaking colloquially. Who cares? Counts 3 and 4, obstruction of justice, or count 5, tampering with a witness. Defendant's challenge to the aggravating circumstances for count 1, that he knowingly created a great risk of death to another, is based on his misrepresentation of both the evidentiary standard at the preliminary hearing and the test for establishing the aggravating circumstance. Now, here's where they take them to a little bit of a legal clinic. As for the evidentiary standard, defendant erroneously asserts that a magistrate engages in speculation when he chooses between reasonable inferences that supports guilt and a competing innocent inference. I said this reading the other thing. That's not speculation, just because if there are two reasonable inferences, both exist. And the deference goes to the state. That's how it goes. That's not speculation. Speculation is to create something out of no evidence. But if there are two reasonable inferences that are competing, it's not speculation to pick one. They cited a case that said it was. They're going to say that that case is overturned. I think they also probably cited it incorrectly anyway. But here we go. Let's see. The Utah Supreme Court has rejected that logic, a fact that the Utah Court of Appeals has repeatedly recognized. Defendants' counsel ignore this controlling case law and have therefore violated their ethical duty of candor to the court. That line. Whoa. Okay. It's poor form. It's poor form to call out another attorney on an ethical violation unless you're really pissed off about it. You don't want to be an edge case. This, I think, honestly, is an edge case. I don't think they violated their ethical obligations. I mean, you have an ethical obligation to be correct in using your citations, but lawyers miscite things all the time. Like they miss something, they don't find proper overruling precedent, etc. Like stuff gets missed. Stuff gets missed, sometimes on purpose. They have a duty of candor to the court. That's true. Them calling them out for violating their duty is them saying that they know this and they ignored it intentionally. It's an intentional misrepresentation, not a failure. It's not them making a mistake. The duty of candor means you have candor with the court. You're honest with them. You're fully honest with them. If you fail your duty of candor, it's because you're dishonest. Wow. This is what I'm talking about. That's a pissed off prosecutor right there. And I think there's reason to be pissed off. This is one of the highest profile cases that's going to happen this year, maybe this decade, right? The prosecutor doesn't want a weaselly, limp dick defense. They don't want that. They want the fullest defense. They want the most robust defense. They don't want some bullshit ineffective assistance of counsel claim coming up on appeal. Tyler Robinson is almost guaranteed going to appeal with ineffective assistance of counsel. It'll be pointless. He clearly has effective counsel, even if they lose, but they always do it. Every murder case, they always try ineffective assistance. Them fucking up a citation badly lends evidence down the road to ineffective assistance. It's not conclusive evidence. It's not full proof, but it's like they mess this up. Prosecution can smell Nestor a couple miles away. You just smell for the cake, right? They can smell her doing this, or whoever wrote it, but the team, they know. They're like, hey, wait a minute, no, you're not getting away with this. This thing, they're working to make this perfect. The prosecution, they're trying to close every single door. To have the defense be sloppy like this, that's kind of a slap in the face. And they're not taking it. It's funny that they're calling them out now. They're doing it here, which is like I said, it's not common. It's not like the rarest thing ever, but it's not common. Prosecutors don't do this unless they actually think it happened, because it's kind of poor form if you're just calling it out. All right. I don't fully agree with the prosecutors. My mic is my mic popping for you guys? Anyway. I don't necessarily agree with the prosecutors here, but you can tell that they're pissed. All right, here we go. Contrary to defendant's argument. Yeah, this mic might be on its way out like my last one. That would be fucking annoying. I'm going to have to get that fixed or replaced. All right. Contrary to defendant's argument, these cases establish that when a fact finder chooses between reasonable inferences at a trial, it is properly fulfilling its fact-finding role, not speculating. Thus, even at trial, a fact finder is free to choose between reasonable inferences. Yes. And I think they go a little too far here. They're not at trial. This isn't relevant at trial, picking between reasonable inferences. They should have just stuck with, at the probable cause hearing, if there are two reasonable inferences, the fact finder doesn't even have a choice. The fact finder cannot choose the reasonable inference that goes in favor of the defense. They can't. It's probable cause hearing. All inferences go in favor of the prosecution, all reasonable ones. So if there's competing reasonable inferences, the one that most favors the state, that's the one. And the magistrate is not allowed to choose the other one. It's not like, oh, well, maybe. No, that's that. So it's definitely, it's so categorically not speculation. It can't be, because they don't even think about it. They can't. Their hands are legally tied to choosing the one in favor of the state. That's the rules of probable cause. That's the system. This is a preliminary hearing where the court does not sit as a fact finder. Oh, hey, see? Instead, this court is duty bound to draw all reasonable inferences in the state's favor. Okay, look, I read this late at night and I didn't read all of it, so I'm glad they have it here. It is therefore even more apparent that in this proceeding, there is nothing speculative about viewing all reasonable inferences in the state's favor. Correct. As for the great risk of death aggravating factor, defendant erroneously maintains that the test for establishing this factor depends on the presence of some minimum number of factors or circumstances. We saw that over and over. They're these three factors. It requires more than one shot. That's their main argument. More than one bullet being fired. That's not anywhere in there. That's just all of the citations that they had. But that's not actually laid out in specificity as a requirement. So they're saying that's wrong. In fact, the Utah Supreme Court has expressly disavowed such an analysis. Instead, the governing test is the one the statute provides, whether a defendant knowingly created a great risk of death to another. The evidence here easily establishes at least probable cause to believe that defendant did so when he intentionally fired his grandfather's high-powered rifle toward a crowd of thousands, several of whom were in the line of fire between him and Mr. Kirk, while others were in close proximity to Mr. Kirk. Close proximity, remember that one came up a lot. Indeed, the evidence is more than sufficient to support a finding beyond a reasonable doubt. Yes. Yes. You cannot fire at a crowd of 1,000 people or 3,000 people, no matter how precise you are. You cannot fire at a crowd of thousands of people and say you're not creating a risk of death just because you didn't hit anybody other than the person that you were trying to kill. I mean, good, I guess, that you got your target and no one else, but everybody there, from the distance he's firing, almost everybody in that crowd would be at risk. If he pulls too hard on the trigger and shifts it all, if he has some radial shift at 150 yards, a couple degrees difference can be quite a big distance. Anybody in like a cone in front of him is in the zone of danger. The only reason they weren't in danger is because he happened to shoot straight. But anything could have caused it to shoot not straight. Anything being real factors. He sneezes. I don't know. He gets nervous. He flinches. Something causes the bullet to fly oddly with a wobble. Dust in the barrel, right? Anything that interferes with the shot happening makes the bullet go somewhere other than where he wants it. This is marksmanship 101. We all know where we want. If the bullets all just went where we wanted, everybody would be a fucking expert marksman, but most people are not. And there's a bunch of things that mitigate it, right? Having a long rifle, laying down in a sniper prone position and having something to rest the rifle on really helps eliminate a lot of that. But we don't know. We don't know that he's going to not fuck up. In fact, he's likely to fuck up. In fact, shooting in the neck is likely a fuck up. There's no way Tyler Robinson was aiming for here. Who would do that? Who would do that? Right? That's movie shit. He's either aiming center mass or he's aiming at his head. Probably his head, because that's the dumber thing to do. And there's bullet drop and stuff. And if you don't know, snipers have a rangefinder. They have someone who's telling them about the wind. They help them calculate out, and they adjust their equipment and they adjust their aim, and they take the shot based on a lot of training about all of those factors and how they affect everything. Tyler Robinson doesn't appear to have any of that training, and he doesn't have a sniper buddy that we know of. He doesn't have a sniper buddy telling him any of these factors. So he takes a shot. A reasonable assumption is that he was going to try and shoot at the head, and he hits him in the neck because he doesn't know how to calculate the bullet drop at the distance. He probably doesn't know the distance off the top of it. He's not doing this math. Most likely he could be. But he also could have been shooting at the chest, and the sight could have been poorly sighted in. Could have been fortunate that he hit Charlie at all. Fortunate, for his purposes. Obviously not fortunate. We don't know. But there's no reason to believe that he was going to be accurate. He just ended up being accurate. And this is the problem with so much legal analysis, is that you're always looking with the benefit of knowing the outcome. So you're like, well, of course no one was in the zone of danger. Nobody got hit. Yeah, but they might have. Literally anything happens. His balls itch at the wrong point and he squeezes a round off and he pops one of the security guards instead. Anything could cause that shot to go wrong. It just didn't. That doesn't mean it couldn't cause it. Have they proved it beyond a reasonable doubt? The aggravating factor? Yeah. Yes. At the pretrial. And the reason they did is because it's an easy one to prove beyond a reasonable doubt. The doubt that they attempt to raise in their brief, in the defense brief, was literally that the state didn't prove that Tyler Robinson saw anybody else other than Charlie Kirk. Their narrative is that he pointed the rifle with his eyes closed towards Charlie Kirk, opened his eyes, only seeing through the sight and already being targeting on Charlie Kirk and not seeing anybody else. That's the defense's argument. Go back and read it. It's that fucking stupid. That's not reasonable doubt. It's also not based on anything. It's not based on anything at all. Based on common sense. On common sense, we know that he had to see other people. We also have, it's also not really true. We know he walked around down there. He talked to people down at the table. We know he knows people are around. But yes, that factor beyond a reasonable doubt, that's not a hard factor. You shoot into a crowd of people. You shoot into a crowd of people and you're putting other people at risk of death. The defense's fact-based argument fails miserably. The defense's legal argument could theoretically succeed. And that's that if the judge agrees that the Utah courts require more than one shot, which they don't, but if the judge agrees with that, well, then they would win on that factor. But that's a legal factor, not a fact-based one, because they have no argument that he shot anywhere other than into a crowd of people. Anyway, defendant's challenges to count 6, witness tampering for directing Mr. Twiggs not to talk to police, and 7, violent offense in a child's presence. This one also Candace got wrong. Likewise, improperly draw inferences in defendant's favor, not the state's, while also ignoring relevant evidence. Correct. And this is probable cause in all of these counts is extremely solid. Even if you think there is still doubt on some of these, I think the witness tampering, maybe there's some doubt there. Maybe because they're going with this purely altruistic theory, etc. Maybe, but like for probable cause though, you don't get to say that Tyler Robinson's statements were altruistic because that requires you to draw an inference in favor of Tyler Robinson and opposed to the state. The same statement can be read as altruistic and as interfering. And if it can be read both ways, the state wins. They're right here. The defense tried it. You tried it. Okay, but they're wrong. And it's the prosecution's job to call them out on it. Speaking of calling out, we have Angel, the Aussie, gifting 5 memberships. Thank you so much, Angel. We love members here on this channel. We love it. And our members are going to be loving our next member show, which I'm targeting for tomorrow. And you're going to enjoy it. Going to enjoy it. Angel the Aussie says, hi, bye. Member for 44 months. See you later, Angel. Thanks for stopping by. Thank you. Finally, defendant also, wait. Sorry. Defendant's challenge to the victim targeting enhancement on count 7 similarly ignores the evidence. All right. Finally, defendant also misrepresents the holding in Apprendi versus New Jersey in arguing that the sentencing enhancements for committing a violent offense in a child's presence and targeting his victim must be proven now. Correct. That's not true. Neither enhancement implicates Apprendi because neither increases the maximum statutorily mandated punishment. And that's the thing people misunderstand about the enhancements. All right. The reason that aggravated murder is separate from murder, right? And the aggravating factor is in a separate statute is because it increases it from life without parole to the death penalty. That's the thing. And they've decided that if you increase the statutory maximum punishment If you do that, then you need to give the person basically another chance to challenge it, right? That's how that works. However, if you're just enhancing the amount of punishment within the statutory maximum with the aggravating factor, if you're still within the same maximum, then you don't need it's not a separate statute. It's not a separate charge, right? So that's what we have there. All right. Angel the Aussie gifting 5 more memberships. Thank you, Angel. I missed you, by the way. Nice to see you. Glad our timelines matched up. Maverick Cuba says, fun fact, I have family on the left that cheer about Tyler taking out Charlie and have no idea that the right wing is even debating the conspiracies. And you know what? The reason is that the conspiracies are unreasonable. They really are. I don't know how else to say it. Maverick Cuba says, Baron is a coal man. Candace is full of too much black girl magic and Lionel is lying about his genetic lineage. Lionel? That guy doesn't look Jewish at all. Maverick Cuba says, I respect you and Owen Benjamin. You two seem to be the most rational on either side of this subject. Maybe one day you guys can talk about it. Clint is a Russell, Barnes is black, and Viva is a Muppet. Oh my gosh. I would talk to Owen Benjamin about it. I don't think we're going to agree on much, but that's okay. I don't hate the guy. Argument 1. Defendant misrepresents the governing evidentiary standard because he relies on an erroneous distinction between inferences and speculation that Utah Supreme Court has rejected. Defendant misrepresents the evidentiary standard that governs this preliminary hearing because he relies on an erroneous distinction between inferences and speculation from State versus Cristobal that the Utah Supreme Court soundly rejected over a decade ago in State versus Ashcraft. The Supreme Court explained in Ashcraft that when a jury chooses between reasonable inferences to reach its verdict, it does not engage in speculation. This is even more true at a preliminary hearing where the magistrate must draw all reasonable inferences in the state's favor. Right. There is no choice. But also it's not speculation. Both things are true. It's not speculative, but also they have no choice, making it double secret plus non-speculative. Because he ignores the case law that rejects the logic on which his argument depends, defendant erroneously labels as speculation many of the state's arguments about the evidence and the reasonable inferences this court must draw from that evidence. For example, although the evidence demonstrates that a clear line of sight existed between defendant Sniper Perch and Mr. Kirk's seat, and 2, that others were near Mr. Kirk when defendant fired the fatal shot, defendant asserts that this court would be engaging in speculation to infer from this evidence that defendant actually observed security personnel or others standing near or directly between him and Mr. Kirk. Similarly, although the evidence shows that defendant loaded his rifle with 4 cartridges and had previously done some target practice where he seldom hit the bullseye and sometimes missed the target completely, defendant asserts that it would be speculative to infer that he knew he could miss his target. Right, but that's not speculative. Those are reasonable inferences. You can challenge the facts, and the defense did challenge, like, how would you even fucking know that those were his targets? Wait, did they? Actually, I don't know if they did that. Maybe I saw that online. Like, how do you know it's his targets? Well, why didn't the defense say that? Now, it's probably because they know that the state can prove it, and they can probably prove it through the testimony of Lance Twiggs or something like that. But who knows? Defendant relies on State versus Cristobal to justify his argument. Quoting Cristobal, defendant asserts that when evidence supports more than one possible conclusion, none more likely than the other, the choice of one possibility over another can be no more than speculation. That's dumb. That's so incorrect. I don't know how to even say it. Like, I can't believe the court wrote that down. I really would like to know the context. Maybe I'll look it up. Not right now, but like that's a crazy thing to say. Fact finders choose between assertions all the time, or choose between inferences all the time. They're the fact finder. That's what they do. They do it based on credibility. They do it based on a whole bunch of, like, whatever they want. That's what the jury does. The jury finds the facts between competing facts. All right. Utah Supreme Court rejected Cristobal's logic in Ashcraft. a fact that the Utah Court of Appeals has expressly and repeatedly recognized. These cases make clear that choosing between competing reasonable inferences is not speculation, but rather exactly what a jury must do. The defendant in Ashcraft argued that the existence of innocent inferences for his presence in a known drug area late at night with a large amount of cash rendered the evidence insufficient to support a jury verdict that he constructively possessed drugs. Consistent with the Court of Appeals reasoning in Cristobal, Ashcraft asserted that his jury engaged in speculation when it credited the inculpatory inferences from the evidence over the exculpatory ones. All right, this is, when they say circumstantial evidence, it's evidence that is based on circumstance. All right? The circumstances surrounding that guy's drug possession, pretty strong. Pretty strong. Is it conclusive on its own? No. The jury has to decide if that's enough to eliminate their doubt. What doubt do they have in the case? We don't know. No idea. However, we know that he was convicted because the jury did think that those circumstances overcame any doubt they may have. Now, the problem is, and I'm going to use this like a teacher, even though I don't know, I have a feeling in my balls about it. Reasonable doubt is doubt that's based in reason on something. Something is the basis for the doubt. If there's nothing to base the doubt on, like no competing narrative, then juries don't really hold doubt. People think that the jury is going to poke holes, right, in their mind, in the narrative, and that's going to be doubt. But the jury doesn't, there's no lance for them to throw through the tapestry. They're not armed with anything to poke the holes. You have to help them. You have to help them. You have to show them either that a fact couldn't happen. It just doesn't, like, there's no way it could happen. Or you have to give them another thing to believe in. You're not required to by law. Don't mistake me. People always mistake this as saying it's a requirement. No, it's just really helpful for the jury if you don't want them to believe your narrative to have another narrative. Most of the time, people don't. The Supreme Court rejected Ashcraft's argument, explaining that the fact that a court could identify an equally plausible alternative inference is not nearly enough to set a verdict aside. This is because law is well established that the existence of one or more alternate reasonable hypotheses does not necessarily prevent the jury from concluding that a defendant is guilty beyond a reasonable doubt. I've talked about this in different contexts, primarily the ICE shootings. Because people are like, oh, well, the officer has to reasonably believe he's in imminent danger. This other officer doesn't believe that. And that officer is reasonable. It's like, okay, that's a reasonable belief, but this officer could reasonably believe it. They have to prove that he could not have reasonably believed it. Now, if every officer ever testifies that they wouldn't believe it, then maybe. But the existence of multiple reasonable decisions, that's always. People reasonably disagree all the time. I think this way, you think that way. If there's not an objective answer that we can find out, then our subjective reasonable assumptions prevail for each of us. They both coexist and they're fine. That's true here. Remember, the state has to overcome all of these reasonable doubts. But the doubt has to be reasonable. Well, I mean, I say has to be. The jury can just nullify the verdict, but the doubt has to be reasonable is the charge to the jury, and they take it pretty seriously. Okay, let's see. This is because the law is well established, the existence of one or more alternate reasonable hypotheses. Oh, wait, I read that. Rather, the jury's exclusive province is to weigh the competing theories of the case in light of the evidence presented and the reasonable inferences drawn therefrom, and to conclude which one they believe. And here's a shocker. If they conclude in favor of the state, the reasonable inference that favors the state, then they've overcome their reasonable doubt. That's it. They've gone beyond their reasonable doubt. And that's something that people seem to misunderstand this as well. People are convicted while reasonable doubt exists. In fact, often reasonable doubt exists in the absence of a more reasonable guilt. I hope that makes sense. What I'm saying is, finding someone guilty beyond a reasonable doubt doesn't mean eliminating the reasonable doubt necessarily. Oftentimes it does, but it also just means overcoming the reasonable doubt. You move beyond it. You've proved something beyond the reasonable doubt. You can technically, reasonable doubt can still exist because you can't make something not happen, or you can't make an inference not exist, but you can show that one is so much more likely than the other that you've moved beyond it. And juries do this a lot. Juries convict while reasonable doubt exists. We know this. We've seen it happen. But the jury is convinced beyond that reasonable doubt. People misunderstand these words, I think, because they mean that they think it means the doubt is eliminated. But it isn't always eliminated. It's overcome. Just like me. Maverick Cuba says, I just found it interesting that the left never knows the debates on the right, yet when I look to the left, they're all just waiting on the next to think. The next person? Okay, here we go. The Supreme Court's holding in Ashcraft, therefore, necessarily overruled the very logic from Cristobal, upon which defendant now relies. The Court of Appeals has also recognized, as our Supreme Court in Ashcraft has since clarified, the fact that we can identify an equally plausible inference is not enough to set aside to set a verdict aside. And here, that's exactly what I was just saying. That's exactly what I was just saying. The appeals court is saying, no, we see that an equally plausible alternative inference, that means equally reasonable, is not enough to set a verdict aside. So they're saying, look, no, we see that there is reasonable doubt here. However, the jury verdict overrides that reasonable doubt because the inference that the jury chose was this one. If they're competing equally and the jury says, we believe this one more, then they win. That's beyond reasonable doubt by definition. People don't think of it that way. I'm guilty of not thinking of it that way, but that's what they're saying. So this is THM Misery. Send some jewels. Thank you. Oh, this microphone's pissing me off.
Question. How does a black swan equal Marin and mu RPM 7 and sigma I equal AT E na sigma abazi cute I frac some I want Marinsa X or I zai RMU to nan sigma and R and they act like standard deviations don't matter. Lol.
Exactly. And we have the Indomitable Green Skull sending some coins. Thank you. Jacqueline Brennan says, Nick, you were right. Candace Owens is just stupid. She told an interviewer dinosaurs were fake. Toy bones were made in China sweatshops and buried for Jews to find. Yeah, I mean, well, I thought you said she was dumb. Like, I thought you said she wasn't smart. What are you talking about? That's what happened. Okay, and citing Wall, the Court of Appeals has repeatedly recognized that Ashcraft is a complete repudiation of Cristobal. Indeed, as this court's opinion in Wall made clear, we no longer view Cristobal's statement regarding equally plausible inferences as valid. A defendant completely ignores Ashcraft, and the Court of Appeals' decision recognizing Ashcraft's repudiation of Cristobal. If the existence of alternative inferences is not enough to justify setting aside a jury verdict of guilt, then it certainly is not enough to justify denying bindover at a preliminary hearing. Correct. A jury is free to pick and choose reasonable inferences in reaching its verdict. A preliminary hearing magistrate is not. The magistrate must view all evidence in the light most favorable to the prosecution and draw all reasonable inferences in favor of the prosecution. At a preliminary hearing, the prosecution is not required to eliminate alternative inferences that could be drawn from the evidence in favor of the defense. Thus, viewing all reasonable inferences in the state's favor at a preliminary hearing is not speculation. It is precisely what the law requires this court to do. Defendant's argument otherwise is based on overruled case law that he refuses to acknowledge and bring to this court's attention. This blatant omission violates counsel's duty of candor to the court. Oh, wait, I don't have this pulled up. I'm sorry. Here it is. Here it is. I apologize. I'm looking at the document, not at the window with me in it, for once. So again, we go back to this failure of the duty of candor. They're calling out the defense here pretty hard. Like, the defense's citation overtly misstates the law. Not only does it fail to account for the fact that it was overturned, let's see, Ashcraft, it was overturned 11 years ago. Just the 11 years ago. Not only that, it runs contrary to the known rules of a preliminary hearing, and it runs contrary to basic criminal procedure. Basic. We know, or anybody reading the defenses, what did Barron say about it? Oh, we're going to have to watch, right? But anybody reading the defense's argument there who knows the law knows that that was insane. The idea that they say, pick between the two. Like, if there's two inferences, like, what do? You pick one. You pick the one you believe more than the other. That's it. That's the jury and the judge's job. If it's a bench trial, that's the jury's job. But here, in a preliminary hearing where all inferences have to fall in favor of the state, there is no picking. It's just the one that favors the state. That's the answer, period. The existence of another one's irrelevant. Okay, here we go. So, citing the rule, a lawyer must not knowingly or recklessly fail to disclose to the tribunal legal authority in the controlling jurisdiction directly adverse to the position of the client not disclosed by opposing counsel. Moreover, an inference is reasonable as opposed to speculative when it is based on evidence. As the Utah Supreme Court has acknowledged, there is no black line between inference and speculation, but a reasonable inference exists when there is at least a foundation in the evidence upon which the ultimate conclusion is based. While in the case of speculation, there is no underlying evidence to support the conclusion. Thus, a reasonable inference, not amounting to speculation, is a conclusion reached by considering other facts and deducing a logical consequence from them. As the state's opening memorandum demonstrated, and is further detailed below, all the inferences the state has identified are grounded in the evidence. They are not speculative, and they support bind over on all counts. And I mean, honestly, you can never, they call them briefs, but they're never brief. But this is it. Like, in reality, that's all that needed to be said. The judge knows the law. Now, they're briefing it. The judge will use the briefs, etc. The judge knows this. The judge knows the law. Everybody knows the law on this one. This is not a mystery. Again, anybody who's in any way tried to convince you that the defense had a reasonable or good argument in their brief is like, as a whole, is wrong. Like, they're wrong. I don't know why they are that wrong, but it's hard to calculate how incorrect they are. The defense's brief was written by people who know that they're going to lose that brief. They did their best. Just the facts and the law are not on their side at this point, at any point, really. And the problem is, very simply, Tyler Robinson did it. Hardest fucking defendant on earth is the one who's guilty. Here we go. Yeah. The Willamagger says only hard to calculate because you're dumb. Yeah, I'm not good at math. Do I look fucking Asian to you? When properly construed, the evidence demonstrates a reasonable belief that defendant knowingly created a great risk of death to another when he fired a high-powered rifle toward a crowd of thousands, including several who were in the line of fire otherwise in close proximity to Mr. Kirk. Just as he misrepresents the legal standard governing this preliminary hearing, defendant also misrepresents the standard for establishing the great risk of death aggravator. The existence of that aggravator does not require a minimum set of factual circumstances which must be present, as defendant claims. Nor is the test a multi-factor analysis, as defendant also claims. When the evidence is properly viewed under the test the Utah Supreme Court has actually endorsed, see, they're pissed, by the way. The evidence demonstrates a reasonable belief that the aggravating circumstance is satisfied here. And we know this because all of the defense's citations, which were voluminous, did not actually support their conclusions. Supporting their conclusions would be a stretch of the language, right? They weren't an opposite to them, but they weren't supportive. What they were doing was saying, well, the court said that this is the aggravating factor. Therefore, the aggravating factors analysis is limited to this circumstance. That's not how that works. That's not exploring the limit. The limit does not exist.
So my reasonableness of eating as much Caption Crunch with berries herein is notwithstanding the weight I will be in the morning? I like this crazy Candace logic. LOL?
LOL? Correct. Okay, defendant misrepresents the applicable test for determining whether he knowingly created a great risk of death to another. In explaining and applying the great risk of death aggravator in State versus Sosa Hurtado, the Utah Supreme Court expressly stated that it was not establishing a multi-factor balancing test. They left that out. They kind of left that out of their brief, I believe. Rather, the ultimate test is the statutory test. And that test requires that the defendant knowingly created the great risk of death. That's it. That's the test. Did they create a great risk of death and did they do it knowingly? That's it. The three factors that Sosa Hurtado court identified to guide the application of the statutory test are simply a range of factors of possible relevance to the statutory inquiry as elaborated in our case law. In fact, the court repeated, we are not here establishing a multi-factor test. Why did the defense leave this out? This is bad work. The considerations in Sosa Hurtado are non-exhaustive and they are not the test. The defense set it up as if Sosa Hurtado was the controlling case on this, and how they determined it is how all of these cases are determined. No, completely wrong. Defendant ignores these portions of Sosa Hurtado. I can't believe that they didn't call them out for a duty of candor there, because they so grossly misrelied on Sosa Hurtado in the defendant's brief. They so misrelied on it that it's actually offensive. And they called him out before, but fuck me. Leaving out, saying the court repeatedly saying in the case, this is not a multi-factor test, but then presenting it as if it was, that's really devious work. Defendant also erroneously urges the court to construe the aggravating circumstance narrowly. The legislature has already narrowed the aggravator by requiring that a defendant knowingly created a great risk of death to another. This court cannot apply its own narrowing gloss to that standard. Again, the ultimate test is the statutory test. Nor does the defendant's emphasis on language from other cases, that a defendant must create a high probability of death, modify the statutory standard. Which, by the way, that high probability isn't there. Great risk. Great risk does not mean high probability. It means if something goes wrong, someone is at great risk. If circumstances don't work out perfect, someone's at great risk. Usually things work out at least close to how you want them to. So you can't say it's high probability, because high probability would mean high probability of failure. That's That's way too high of a bar for the aggravator. A high probability of death is just another way to say a great risk of death. I disagree with that. Other courts use the term high probability, therefore does not modify the statutory test. I mean, I agree that the statutory test is not modified by it. I think the court saying that circumstances in a particular case created a high probability of death, that's just going beyond a great risk of death. That's showing that the great risk existed because a high probability existed. But great risk occurs at low probabilities too. Just because something has a lower probability doesn't mean that it's not a great risk. The great risk, I mean, death itself is almost like it's a great risk because the loss is so catastrophic. So if there's any likelihood of it happening, you're stepping into great risk territory, in my opinion. It also makes no difference that the facts of other cases do not precisely fit the facts here. Defendant spills much ink, and that's a good line because that's true. They spent pages and pages on all these other cases that didn't really have anything to do with it. Detailing the facts of other cases where courts have analyzed the great risk of death aggravator. But the fact that other defendants did more to endanger others, like firing multiple shots, than defendant did here is not persuasive. The issue is not whether another court has applied the aggravator in a case with identical or at least highly similar facts. Rather, the issue is whether the evidence, together with the reasonable inferences therefrom, when properly viewed in the light most favorable to the state, supports a reasonable belief that defendant knowingly created a great risk of death to at least one other person. The ultimate test is the statutory test. Again, the state has comfortably surmounted that low bar. And it is a low bar. That's the hearing we're in. But I just want to make a point in the defense's favor here. What the defense did is they said, there's a rule and the language is open to interpretation. It's not open to a complete change, but they say, okay, well, what is a great risk of death and what is knowing? Those are the two things. The defense does not have a case. I mentioned this while we were reading through all of them and going, on all of these, they found, these are bad sites because on all of these, they found the aggravating factor just about. I think there was one that they didn't in a different state. But in pretty much all of them, they found the aggravating factor. And they listed off why they did. So the defense is trying to use that to say that there is a de facto standard and that it's higher than what happened here. The reason they did that is because that's all they could do. They don't have a case saying that the standard is any different than what the statute says or how specifically to read it. They didn't find a case that says, here's what the great risk of death means. Because a great risk of death isn't that confusing. So the courts haven't needed it, I don't believe. It's pretty obvious when it happens. If you shoot at a crowd of people, there's a great risk of death to other people. That's it. And so the defense did their best. They have no case directly on point, so they tried to establish a standard based on what they found. Now, I don't know if they left stuff out, very possible, but it doesn't really matter. They didn't do it right. They lose. This court must also recognize that while Sosa Hurtado analyzed and applied the great risk of death aggravator, it did so in a different context and therefore had a different focus. Sosa Hurtado fired 3 shots at 2 different people. He fired the third and fatal shot at his victim at close range and with his back to the other smoke shop employee. The issue in that case therefore concerned the scope of the relevant circumstances that a jury could consider in determining whether the aggravator was satisfied. As the court explained, the issue is whether the relevant circumstances extend beyond the precise act that caused the death of the victim. Okay, so what they're saying is, this guy's in close proximity, but he's behind him. Can the jury consider the close proximity if it's, is he really at a great risk of death if he's shooting this way and the person's that way, but they're close? I think we find that they said, yeah, the jury can consider that. So here we go. As the court explained, the issue was whether the relevant circumstances extend beyond the precise act or whether the aggravator applied only where the murderous act itself creates a great risk of death to a third party. And so, yeah, like, is the person at risk of being murdered because there's a guy murdering people? Is the question maybe for the jury. The court ultimately held that the relevant circumstances include more than just the murderous act itself. So again, shooting this way when there's someone close by behind you isn't the only factor. Is the person at risk of that guy turning around and shooting them, of a ricochet, like a whole no? The jury is allowed to consider it. Doesn't mean that they'll find it. A person may be guilty of knowingly creating a great risk of death to another person if he did so within a brief span of time of the act causing the murder, and the acts together formed a concatenating series of events. Unlike Sosa Hurtado, this case involves only the murderous act itself. Right. So what the defense tried to do is say that the murderous act happens and then a concatenating series of events has to happen in line with that murderous act that causes the great risk of death. Now, I talked about the concatenating series of events starting before the murder, right? Like the events of him getting into position, lining up his rifle, etc., which is one way to look at it. They're saying that it doesn't really matter because pulling the trigger in and of itself is fine. I was relying on the defense's characterization of things and talking about it in that context, but they're saying the defense is entirely wrong. And I tend to believe the prosecution here. The evidence supports a reasonable belief that the statutory test for the aggravator is satisfied here. Although Sosa Hurtado was focused on the scope of the relevant circumstances that can support the aggravator, its analysis is nevertheless helpful here. This is a good line. The way they wrote this, they're saying this case actually doesn't speak directly to our case. They're different. It's examining a series of events. Ours is analyzing just the murder, but there is helpful stuff here. They're saying that both of those things fit under the statute. The defense said the opposite. I think the defense is wrong, but we'll see. It's nevertheless helpful here because the Supreme Court recognized that firing a rifle at a murder victim while another is close by creates a great risk of death to the surviving person. We talked about this. As explained in the state's opening memo, the Sosa Hurtado court recognized that there were two separate acts that created a great risk of death to the surviving smoke shop employee. The first act was a shot fired towards that surviving employee that missed. The other was a shot that hit the murder victim in the hand while the surviving employee was only a few feet away. Thus, contrary to defendant's contention, Utah has, in fact, adopted an interpretation of the aggravating factor that would permit its application where firing of a single shot at an intended victim hit only the intended victim. So they're saying there's two separate things, like the shots are actually analyzed separately. Here, there were several people close to Mr. Kirk when the defendant shot him dead. Most significantly, the questioner was directly between defendant and Mr. Kirk and within a few feet of Mr. Kirk. There were also several people who were near the questioner. There were also those with Mr. Kirk who were under or near his tent. All these people were visible in the clear line of sight between defendant's perch and Mr. Kirk's seat. Indeed, from a distance of 410 feet from Mr. Kirk, basic mathematics dictates that an angular shift of even 1/8 of an inch, they should have done that in radians, would result in a substantial miss of the intended target, either above, below, right, or left, depending on the direction of the shift, placing many others in danger. Given these facts, two of the three Sosa Hurtado factors support the conclusion that the great risk of death aggravator applies. This is interesting because they just said it's not a multi-factor test, but they're applying the test anyway and showing that it still supports it. As explained, the spatial relationship between those in the line of fire and or close to Mr. Kirk supports application of the aggravator. Defendant also threatened these people by indirect means through the risk of a stray or ricocheting bullets, the other Sosa Hurtado factor. The time between the murderous act and any other acts the defendants may have taken towards third parties is simply inapplicable here. So yeah, they're saying like, you can't ever pass that test or that factor because there's only one shot. He doesn't do anything towards any other defendants. Now he could have like jump kicked someone from the roof or whatever. Like there's theoretical possibilities other than shooting. Again, he could have gotten in a car and run over a kid or like almost run over a kid or something. That would have been a series of acts, right? But they're saying it's inapplicable. And then that should tell you the fact that there's one part of the test that simply cannot be satisfied even though other people are at great risk, that's not part of it. But the other thing that should have told him that is that it says it over and over and over. This is not a multi-factor test. Okay, consideration of the Sosa Hurtado factors therefore supports a reasonable belief that defendant knowingly created a great risk of death to those who are in defendant's line of fire and those who are close to Mr. Kirk but outside the line of fire when defendant pulled the trigger. Yes, I mean, this is obvious. Defendant's attack on the state's line of fire argument, which he repeatedly mislabels as a line of sight argument on the basis that Mr. Kirk was seated in an elevated position. Defendant asserts that the bullet traveled above, not through the crowd. But in State's Exhibit 8, the questioner's head is visible above Mr. Kirk's head. Oh. Others standing in the front rows of the crowd are positioned at approximately the same level as the questioner, but slightly farther back from Mr. Kirk. And regardless of the precise elevation of the questioner's head and the heads of the others in the crowd in relation to Mr. Kirk's head, any difference is so negligible that it does not place the others outside the line of fire. The evidence therefore supports a reasonable belief that all these people were in the line of fire. Remember I said, well, maybe you don't, but I said in the defense one, they should have included the math, the trigonometry, whatever, that shows where the bullets line had to go and shows where each person is to show they were at no risk. That would have been something to do. There's a reason they probably didn't, because it wouldn't have been helpful. That wouldn't be dispositive, by the way. The state would still overcome that, but they could have at least tried. The evidence therefore supports a reasonable belief that all these people were in the line of fire and therefore within the zone of danger the defendant created when he fired his rifle. By the way, the zone of danger is beyond the line of fire. It's necessarily bigger. That's why it's a zone and not a line. The zone of danger from a rifle is a cone to some degree in front of the rifle, because it must account for the possibility that there's lateral movement or vertical movement. So it's a three-dimensional cone that goes out. That's why it's a zone of danger. All right. That defendant created when he fired his rifle. Defendant knowingly created great risk of death to the people who are in his line of fire. Line of fire is just within the zone of danger. The zone of danger is bigger. That was the point I was trying to make there. Defendant knowingly created a great risk of death to those near Mr. Kirk when the defendant pulled the trigger. 100%. Like, obviously, this is true. Defendant also knowingly created a great risk of death to those near Mr. Kirk, although not within the line of fire. 2 security personnel were directly in front of and on either side of Mr. Kirk, but still within the span of his tent. A 3rd security person was under the tent and just to Mr. Kirk's right. This person had to take only a small step to reach Mr. Kirk as he fell. I thought so. I remembered seeing that. Another person was operating a camera just under the tent's front edge and to Mr. Kirk's left. Defendant had a clear line of sight to view all these people from just 410 feet away. I don't know why it says just. The evidence also supports a reasonable inference that defendants knew that people were in the area behind Mr. Kirk's tent. Defendant visited the amphitheater area at least twice before the shooting. This evidence supports a reasonable inference that he saw the staging area behind Mr. Kirk's tent. The fact that defendant had a clear line of sight to Mr. Kirk's tent at the time of the shooting also supports a reasonable inference that defendant knew people were at that staging area when he fired. Defendant argues that given the speed with which he had to acquire his target and fire once he got into position in the sniper's nest, that the evidence does not support a reasonable inference that he knew any of these people were present. But this argument again ignores the controlling evidentiary standard because it asks the court to view the inferences in defendant's favor rather than in the state's. Defendant had a clear line of sight to Mr. Kirk, the crowd, those nearest Mr. Kirk, and those in the staging area behind the tent. The evidence therefore supports a reasonable inference that defendant knew that all the above mentioned people were near Mr. Kirk when defendant fired his rifle. And defendant had longer than just approximately 35 to 44 seconds in the prone position to observe these people. He would also have seen these people as he ran and then crawled towards the rooftop position. Yes, of course. But the 35 to 44 seconds that he had is more than ample. Regardless, emphasizing how hastily defendant had to act to acquire his target and fire his rifle does not help him. Correct. Especially because of the reasonable inferences going in favor of the state, you would reasonably infer that finding his target meant excluding other targets. That's a reasonable inference. It only highlights and increases the likelihood that he would miss his intended target. The speed, they're going a different direction also, but The speed with which the defendant had to act, coupled with evidence showing that he had to reassemble his rifle and that he loaded 4 cartridges in his rifle. And by the way, the state's evidence establishing that he had to reassemble his rifle might be disproven at trial. It's not dispositive to the case. But here it's assumed because the state has presented evidence of it and the inferences drawn from it go in favor of the state. The defense would have to show that that was impossible in some way. They didn't do that. They didn't even try because they couldn't. Whether or not he reassembled his rifle, I'm not convinced either way on that one. I also don't care. I know the rifle was up on the roof. We watched him run away with it. Let's see. Sometimes missed the target entirely. All supports the reasonable inference the defendant knew he could miss. The inference supports a reasonable belief that he knowingly created a great risk of death to both those in his line of fire and others near Mr. Kirk. Again, a jury can infer that an individual is knowingly endangering a person when the individual uses a gun in any area where he knows that others could be, citing Commonwealth v. Watson. And that's obvious. This is such a well-established part of criminal law, that using a gun is deadly force. You can shoot someone, like you can put the gun up to a big toe and pull the trigger. It's still deadly force, period. Like firing a gun at someone is deadly force presumptively. This isn't a question. It's weird that I guess it's not weird. The defense is trying what they have. But it's not like they were going to win there. Common sense also dictates that firing a gun, especially a high-powered rifle, towards others puts them at great risk of death. That is precisely why gun ranges prohibit shooters from even handling a firearm when others are downrange beyond the firing line. Defendant highlights cases where other courts did not find that the facts satisfied the great risk of death aggravator. But again, the issue is not how closely the facts here resemble those in other cases. The issue is whether the facts here, together with the reasonable inferences therefrom, demonstrate a reasonable belief that defendant satisfied the statutory aggravator. And none of these cases resemble the scenario here. Correct. None of them were even close. Moreover, some of these cases support application of the aggravating circumstance in this case. For example, although the defendant in Littlejohn versus State fired only one shot in a convenience store that hit his intended victim, the court recognized the aggravator applies when the defendant acts create a risk of death to another, which are in close proximity in terms of time, location, and intent to the act of the killing itself. There is no mention in Littlejohn of how close others in the store were to the person who was shot and killed. Similarly, although the court in Johnson versus State found that the defendant did not create a great risk of death. I overlooked what they were talking about here. Close proximity is not necessarily literal physical proximity. It could also mean location. The location of inside a convenience store is close proximity. So it's not a ring of like a 3-foot radius or a 5-foot radius or 10 foot. It's not a bright line rule like that. Close proximity means close proximity. Sometimes convenience stores are really like small cramped areas. Even if you're 10, 15 feet away, the close proximity creates risks, like necessarily. One, ricochets are a real problem, a real potential problem. But there are other risks in there too. There's a risk of causing a heart attack, for example. We know that if you cause a heart attack while committing a felony, if your act is tied to that, you get felony murder in many states. Similarly, although the court in Johnson versus State found that the defendant did not create a great risk of death to another when he fired at a store manager at point blank range, the court also noted that no other person was within the immediate vicinity or within the line of fire, as is the case here. So they're just drawing distinguishing factors between ones that weren't favorable. Finally, the court statement in U.S. versus Bin Laden about a defendant who might carefully target his victim does not help defendant here. That court posited that a jury may find there to be a qualitative difference between a defendant who carefully targets an intended victim or victims without endangering others, and one who acts with indifference to additional persons. But defendant here acted with indifference to those in his line of fire and close to Mr. Kirk because his shot endangered them, even though it ended up hitting its intended target. So they're saying, of course, Someone could demonstrate extreme precision and care, and he didn't. He didn't do that. Demonstrating extreme precision and care would probably mean doing it while no one was around. Many of defendants' arguments depend on ignoring some evidence and improperly viewing the evidentiary inferences in his favor. Defendants' argument that the evidence does not establish probable cause to satisfy the great risk of death aggravator are also unpersuasive because they ignore evidence and improperly view other evidence and reasonable inferences in the light most favorable to him. Defendant's argument that he did not have to reassemble his grandfather's rifle ignores the evidence that the rifle was in at least two pieces because he was both walking with a limp and carrying a backpack as he approached and climbed onto the roof. It also ignores the fact that the defendant left a screwdriver on the roof near the railing that he flopped over to access the sniper's perch. Defendant omits the screwdriver on the roof from his recitation of the facts. And even if defendant could have concealed the entire rifle in his pant leg, transporting it that way supports a reasonable inference that the scope would not be in the same position that it occupied when defendant sighted in the rifle, assuming that he did so before the shooting. They're pointing out, by the way, that the scope not being sighted in, which is often alluded to by the conspiracy side. Like, oh, if you had to reassemble a rifle, the scope isn't zeroed. Yeah, that's part of the problem. That supports the aggravator. If it's not zeroed in, then it's not as accurate. Now, just because he hit Charlie doesn't mean that the scope was actually zeroed in. The targets found in defendant's apartment and the 4 engraved cartridges loaded in the rifle likewise support the reasonable inference that defendant knew he might miss. Defendant's argument that the targets might be completely unrelated to the murder is undermined by their continued presence in his apartment and the discovery of a cartridge in his apartment that he had engraved with the words "test shot." Dumb. And whether those targets are related to the murder or not, their presence in defendant's apartment supports a reasonable inference that they record his shots. And that's true. That's true. That may not hold up at trial. The jury may not accept that. But it does support a reasonable inference that it's his. It's in his apartment. The targets show that he seldom hit the bullseye and sometimes missed the target altogether. Lance complained about the same thing. In sum, because the evidence demonstrates probable cause for each element of count 1, aggravated murder, the court must bind defendant over for trial on that count. Yeah, I agree. Obviously, I agree. We've been through this. The Atomisk says, is the panic of the crowd not a risk of death? Okay, you said something very important here. You said, is it not a risk of death? Yes, of course it's a risk of death. People get trampled all the time. Is it a great risk of death? At a probable cause hearing? Yeah, I would think so. At trial, I don't know. Saying someone is at great risk of death from trampling, lots of crowds disperse, especially in shootings, and we don't hear a lot about tramplings. Is it a risk? Yes. Does it rise to great risk? I don't know. I think that's one of those instances where you go, okay, maybe not. But that's a good question. Okay. Contrary to defendant's assertion is about obstruction of justice. His direction to Mr. Twiggs to not talk to police does not unequivocally demonstrate that defendant meant only to help Mr. Twiggs rather than obstruct an investigation. Defendant's argument otherwise improperly draws the inference in his favor. Right. You can take both inferences. Both can be reasonable. The court is required to accept the states here. Moreover, defendant ignores that his direction to Mr. Twiggs about the police came in the same conversation in which defendant also directed Mr. Twiggs to delete their incriminating text messages. And this bit of evidence, one on its own, the deleting of the text messages, but also that weighs in the state's favor also. In regards to the don't talk to the cops. The conversation also included defendant explaining how he concealed his rifle and changed his clothing. Right. And of course, that conversation is some of the most damning evidence that exists. Although defendant claims to contextualize his statement to Mr. Twiggs, he actually ignores the full context of his statement. Ignoring incriminating evidence does not make it go away. State versus McNeil. Properly viewed, the evidence supports a reasonable inference the defendant intended to obstruct an investigation when he instructed Mr. Twiggs not to talk to police. The evidence therefore requires binding defendant over on count 6, witness tampering. 100%. Of course, all of this does. Here's the thing. You don't get to contextualize your statement. If you're contextualizing evidence at a preliminary hearing, you lose. There's no contextualizing it because the context can go either way. So if you say, no, here's the context. The state can ignore, or the court is required to ignore your context. The only context you could provide would have to be to eliminate the possibility. To show the texts were forged, for example, if they had evidence saying pretty conclusively that the texts were made by someone else. Okay. That would do it. But other than that, you can try and change the context all you want. It doesn't fucking matter. Here we go. 1 second.
Logic and reasoning applied to a crazy ass act sounds like snobby people trying to make sense of shit that gonna make no sense. Tyler wasn't using his gat in a shooting contest. He done went crazy blam.
Exactly.
Harley, you bit me. John's dead.
Exactly. This is something that is, it's a temptation in these types of cases, and in every case, is to assign reasonable behavior to someone acting categorically unreasonable. Murdering Charlie Kirk is not reasonable, right? Assassinating someone is outside of the norm of human behavior. So why are we assuming, and again, this is when we're drawing inferences that must go in favor of the state. They must. That's the rule. How can we rely on the defendant being rational when we're drawing those inferences? Logically, we must assume the defendant is acting irrationally because he is. He's murdering someone. That's not normal. That's not normal at all. Okay, so here we go. Properly viewed, it supports a reasonable inference. The evidence, therefore, requires binding over on count 6. So now this is evidence supports a reasonable inference that he knew at least one child was present when he shot Mr. Kirk. An apprendee does not require the state. Okay, we're going to get through this quickly and we're almost done. The evidence supports a reasonable inference that defendant knew a child was present. Defendant's argument that there is no evidence from which this court can infer a reasonable belief that he knew a child was present focuses only on the short time the defendant was on the Losi building roof. I also think that that's not really the best argument because it's entirely reasonable to assume that a child was visible. Defendant ignores the evidence that he was in the amphitheater area at least twice on the morning of the shooting, including eating lunch at the Sorensen Center that borders the amphitheater. As explained, when all evidence is considered, it supports a reasonable inference that defendant saw the attendees that were gathering for the event, including the children who were present. But even if the evidence was limited to just the time defendant was on the roof, he could see the entire crowd from that vantage point. That evidence alone supports a reasonable inference that he knew at least one child was present. The evidence therefore requires binding defendant over on count 7, committing a violent offense in a child's presence. Apprendi does not require the state to prove this aggravating factor or the victim targeting enhancement for counts 1 and 2 at the preliminary hearing. Now there's two things going on. The violent offense committed in front of a child is a crime, but is also an aggravating factor in other crimes. So there's a distinction. They're saying that in the other crimes where it's an aggravating factor, they don't have to prove it in this brief or at pretrial. But they do for the crime. The separate crime requires the probable cause. Okay, defendant also misrepresents the holding in Apprendi versus New Jersey in arguing that the state must establish probable cause at the preliminary hearing to support the violent offense in a child's presence aggravating factor for counts 1 and 2 and the victim targeting sentence enhancement for those same counts. Right. I want to point out, I did independent research on this and I posted it on Twitter after I read the other document, and the prosecution's right here. Like, they don't. There's actually nothing, as long as the aggravator is within the statute and does not increase the sentence beyond the statutory maximum, they don't have to prove it at the probable cause hearing. Contrary to defendant's representation, Apprendi did not hold that any fact which increases a potential punishment in a case are elements of the offense which must be proven to a jury beyond a reasonable doubt. They're saying it did not hold, and they quoted it. Rather, Apprendi held that any fact that increases the penalty for a crime beyond the prescribed statutory maximum must be submitted to a jury and proved beyond a reasonable doubt. Correct. A jury has to approve the sentencing on the aggravating factor. Neither the violent offense in a child's presence aggravating factor nor the victim targeting enhancement implicate Apprendi, because neither increases the penalty for counts 1 or 2 beyond the prescribed statutory maximum. The violent offense aggravator requires only that the sentencing judge or the Board of Pardons and Parole shall consider as an aggravating factor in their deliberations that the defendant committed the violent criminal offense in the presence of a child. It does not increase the statutorily imposed maximum penalty for aggravated murder beyond death or the penalty for felony discharge of a firearm beyond 5 years to life in prison. So it's a factor for the judge to consider. Sentencing, aggravating factors in sentencing are typically discretionary, or maybe for the fact finder. I don't know if Utah juries do the sentencing or if the judges, but I'm getting that it's the judge. Sentencing judge, yeah. So they are allowed to consider a whole swath of things. But if they're basing their decision if they're making the decision on an aggravating factor that increases the statutory maximum, then it has to go to a jury. Otherwise, they get to just factor it in themselves. Well, the facts have to go before the jury. You know what I'm saying. So too for the victim targeting enhancement. Because counts 1 and 2 charge a capital and first-degree felony respectively, the victim targeting enhancement does not increase the level of those offenses or the statutory maximum punishment for those crimes. Rather, like the violent offense aggravator, the victim targeting enhancement requires only that the sentencing judge or the Board of Pardons and Parole shall consider the defendant's selection of the victim or property as an aggravating factor. So that's just for them to make the decision within the guidelines. Because neither the aggravating factor nor the sentencing enhancement implicate Apprendi, the state is not required to prove their elements at this preliminary hearing. Yeah, I agree. Rather, as explained in the state's opening memorandum, the state is required to prove the victim targeting enhancement only for count 7, committing a violent offense in a child's presence, because the enhancement raises that crime from a Class B to a Class A misdemeanor and therefore increases the statutory maximum penalty. Great. The evidence supports a reasonable inference that defendant targeted Mr. Kirk because of his perception of Mr. Kirk's political expression. So now they don't have to prove it out here, but they're going to say they did anyway, right? As with several other of his arguments, defendant again ignores the critical evidence in asserting that the state has not established probable cause to support the victim targeting enhancement as to count 7. Most importantly, defendant ignores that he engraved one of the cartridges in his grandfather's rifle with the overt political reference, "Hey, fascist," catch. That alone is sufficient to establish a reasonable belief that defendant targeted Mr. Kirk because of his perception of Mr. Kirk's political expression. Again, ignoring incriminating evidence does not make it go away. Defendant also ignores the evidence that as TPUSA's leader, Mr. Kirk's avowed purposes included promoting and debating political issues, and that his events on college campuses were intended to further political ends. As explained, Mr. Kirk's goals included helping people develop the knowledge, skills, values, motivation so they can meaningfully engage in their communities to restore traditional American values like patriotism, respect for life, liberty, family, and fiscal responsibility. Great. Yes, killing Charlie Kirk is obviously political unless you somehow show that it's not. Like that it was random. He was just going to shoot somebody and it happened to be Charlie Kirk, which would, I mean, I guess you defeat that factor, but then you just go ahead and admit to everything else. Defendant further ignores the evidence that to accomplish these aims, Mr. Kirk would hold events like the one at UVU to discuss America's founding principles and political doctrines, and to persuade attendees to follow a mindset rooted in politically conservative values. All this evidence, along with that discussed in the state's opening memorandum, establishes a strong inference that defendant targeted Mr. Kirk because of defendant's perception of Mr. Kirk's political expression. This is typically true when this evidence is considered in light, especially true when this evidence is considered in light of defendant's admission that he killed Mr. Kirk because defendant had enough of Mr. Kirk's hatred. The evidence therefore establishes probable cause to support count 7 as an enhanced class A misdemeanor. And even if Apprendi applied to the victim targeting enhancement as to counts 1 and 2, which it does not, the evidence establishes probable cause anyway. So yeah, they just fully rounded out. They fully rounded out their argument. Very well done. Their conclusion is really short because there's nothing left to be said. For these reasons, and those in the state's opening memorandum, the court should bind defendant over for trial on all counts charged in the information. There you go. Jeffrey Gray. With that, I'm going to run to the bathroom. I'll be right back.
He drank a fair bit and then realized that his bladder can't handle the liquor inside, leaving us with his chair while he runs up the stairs, hoping the stream doesn't suddenly die. While we are waiting, we'll be laughing at you. The drinking along is what most of us do. The chat is united, getting excited for what you have for us when your being is through. When you have a small bladder and no sphincter control, freedom of the liquor doesn't mean freedom from soaking your drawers. Now you're washing your hands and you realize that you've forgotten to scrub both the front and the back. Then you'll grab a quick bite, kiss your lady goodnight, and remember to thank her for all of the snacks. Whoa, water will cure your hangover. Oh, so drink some when the stream is over. When you have a small bladder and no sphincter control, freedom of the liquor doesn't mean freedom from soaking your drawers. Soaking your drawers.
Okay. Okay. Sorry about that. I am back. Whew. Sometimes I need to go to the bathroom really bad. You know how it goes, don't you? All right. Let's summarize that filing. Filing's a sledgehammer to the defense. They call out the defense very specifically on misrepresentations that the defense made, going so far as to suggest that they were a violation of the defense ethical obligations. That's a powerful statement. Like that's a lot. The defense misrepresented the law, and they misrepresented the case law that they were relying on for their misrepresentation. They did both. It's not a mistake. They omitted critical language from the case that they spent the most time talking about, I believe, which was Sosa Hurtado, which pervades pages and pages of their brief. They lied about their biggest argument. That's not good. That's not a good way to do this. If you do that and the other side calls you out, well, one, you look foolish. But you don't just look foolish, you look intentionally dishonest as well. That's part of being the fool, is being intentionally dishonest. The court is going to find that out. The other side's going to call you out. So either they did shoddy work or they lied, which is bad both ways. Chichunia sent a silver star. Hey, thank you. How's it going? Malkaron says, sorry if already covered this, but Charlie Kirk security wanted to lock down that roof and put up a drone, and the campus refused and said it would be, I'm guessing you're saying excessive or unnecessary, or it would be locked down or something like that, but it seems to have been cut off. Wanting to lock down the roof. Yeah, I mentioned that earlier. I mentioned that the roof should have been locked down. Access to it should have been stopped by the school. Charlie's security team shouldn't have had to worry about that. But maybe they should have checked. Who knows? But if they said to the school, hey, we want this locked down, the school said, yeah, we got it, and then they didn't do it, well, I mean, then I guess Erica has a wrongful death claim against the school. But I want to not get bogged down too much in this. I got like a mullet going. I want to not get bogged down too much in this because of some critical considerations. Yeah, they might have stopped Tyler getting on the roof. There's nothing to say that Tyler doesn't go somewhere else and make the shot. Nothing to say that. So while they may have eliminated what happened, the nature of this type of event is necessarily unpredictable. You can't lock down everything. You can't cover every contingency. There's not enough money. There's not enough money and not enough people. That's just a limiting factor of all of this. And the overwhelming majority of the time, nothing's going to happen. Nothing's going to happen because there's a bunch of dudes walking around with firearms, or they're big and scary, whatever it is. You know, there's security. You don't want to go to prison. You don't want to end up in an arm bar or shot. So most of the time, the presence of security is a sufficient deterrent. A lot of other times, there's some tip. There's some indication. Someone was in this case, it didn't happen this way, but you could imagine that Tyler might have fantasized about killing Charlie Kirk in the Discord. This doesn't seem to have happened, so please don't take that as an assertion. But he might have fantasized about it, and one of the Discord people might have contacted some law enforcement agency, FBI, whatever, and say, hey, this guy, he's saying some weird shit about murdering someone. That happens with more frequency than people think, I think. Someone says they're going to do something awful, and then someone else is like, well, I don't know if I want to. They get nervous because they're a part of it, even if they don't want to be, right? Like they're in that Discord server and someone says something. If they don't report it, people feel culpable. They feel responsible. They might be criminally responsible depending on the circumstances. So they go to the authorities with regularity. When people talk in even semi-private rooms with groups of people, you get beyond one or two really trusted people. You get outside of that, and those circles get a little bit bigger and a little bit bigger. The people don't know you quite as well. Maybe not as crazy. You don't hold the exact same political beliefs. Suddenly, your crazy stuff sounds crazy to someone. They might have agreed with you on tax issues, but, kidnapping the governor or whatever. It's a joke. We know that was a fed up because it was, like, literally was. But anyway, but you get the idea. When things start to get real, people do get afraid. They do have a conscience. Most people aren't murderers, and they don't want to be in any way participating in that. So maybe you keep a private chat with a couple people and you're free to say literally anything. Those are your ride or die homies, right? And they might have to ride or die depending on how insane you are. But outside of that, it's very frequently reported. We have no indication of that. In fact, we have some evidence to support the idea that Tyler Robinson was exceptionally quiet about this. We have evidence he was exceptionally quiet because Lance said so. Now again, people who misunderstand evidence, people who misunderstand facts, and who don't understand inferences go, well, Tyler Robinson never talked about killing Charlie Kirk and didn't really talk about politics much at all. Therefore, he didn't do it. Jews did. I'm sorry. Whether someone speaks publicly about their planned murder, that's not the most common thing. A lot of times because people's plan isn't as robust. I mean, he planned this for a week, he said, about a week of planning. That's pretty quick. That's pretty quick for a murder. But it's also pretty long for a murder. A lot of murders happen real quick, like within a few minutes. There's not a lot of planning because they involve very heightened emotions, some outside influences usually, and some bad decisions that people regret. Here he planned it for a week, which is both long and short. But when Lance Twiggs says, yeah, Tyler, and we never really discussed politics. One, that's a little bit self-serving if he's trying to protect himself from culpability. Like, I had no idea. But he has use immunity, so I don't think that would be a problem for him. However, I don't know his exact immunity agreement, right? Like, we don't know the full scope of it, so I don't think it's available publicly. But so maybe that would be a problem for him. But either way, the most likely outcome is that Tyler didn't really talk much politics, and he didn't talk about shooting Charlie Kirk. Okay. What inference do we draw from that, though? That security would have had no way to know that this fucking dork was going to shoot him. Normally, a crazy motherfucker has a manifesto. I say normally. Often, a crazy motherfucker has a manifesto, has someone that they've told. And that tip gets out there in some way. When these people are stopped, when lunatics are stopped from doing their bad act, it's because the information did get out. They couldn't keep it quiet. But all the time, people don't say they're going to kill someone, and then they go kill them. It's weird how that works, but that happens often. And people have no idea. People may not have known that a person holds like serious political beliefs that drive them to murder, because it's outside of the way we normally think. Like, you're not, when you see someone at the grocery store, you're not like, I bet that guy is a First Amendment auditor. You're not thinking that. You're just like, it's a guy at a grocery store. Unless he's yelling at someone, and it's a First Amendment auditor. But this actually just goes to support the notion that the security team would have no way of knowing that someone was going to climb up on a roof and shoot Charlie Kirk. I see people arguing whichever way you want, and that's fine. Like, discuss it all day. That they wanted to lock it down, or they should have locked it down. Yeah, they should have done something different because he should still be alive. Like, that's true. But them knowing what it should be in the time that it happened, that's less true. Now, if they wanted to lock down the building and it didn't get locked down, maybe they should have fucking checked, right? But again, practicality gives way at some point to the whole purpose of security, which is overwhelmingly just theater. The visible presence of security is the security. That's what's stopping most of the problems that could happen. So once we understand that, we realize that Charlie's security team failed, but their failure isn't like particularly strange. In fact, I would argue that most security teams probably fail when there is an actual attempt at an assassination. But it doesn't happen very often. KDK, yeah, it's their job to think of the unthinkable. Yes. How many security people do you know, though? This is kind of a weird statement. I think it's a bit of a paradox. And I'm not picking on you here. I think you're very nice. So I don't want to come across in any negative way, but we say it's their job to think of the unthinkable, but security is all about calculated risk reduction. So it's literally the thinkable. That's what their job actually is. I guess to think of the unthinkable, but you can't plan for the unthinkable. You go with the thinkable, and you go with the most common thinkable things, which is why Valhalla was saying like security happens in rings. Like you have different zones of caution and danger, and you have it's not necessarily linear. It's not a linearly decreasing risk, because guns are a force and range multiplier. So, for example, the farther away you get, the less physical danger someone's in from like a punch. But when you get to a certain distance, they become really, really at risk of like a rifle. At some distance, they're most highly at risk of a handgun. The person's not going to get as close as they could. But it's easy to say stuff like it's their job to think of the unthinkable. If your job is to think of something that can't be thought, you will fail it. And I would posit you're right in that security often fails to think of the unthinkable. I think that's pretty obvious. We have had several lessons throughout history. But I also think that's not their only job. Their other job is to apply the thinkable as best they can and execute it. People can assess the security job that they did here. Erica Kirk praises the security team, and that bothers people. Erica Kirk also forgave Tyler and stuff like that. You know, that's kind of like maybe her perspective on how to deal with the reality. Like, what are you supposed to do? She can hate Tyler Robinson for the rest of his life or her life, and that won't bring Charlie back. So maybe forgiveness is the better way. Same with the security team. She can praise them, and I would wager it's probably because she knows that the security team tried and had no reason to want to fail, right? Like the idea that the security team would have failed on purpose, you got to show me something on that one. You got to show me something, because I'm not saying that they're all giving each other blowjobs or whatever, but I would wager that Charlie Kirk developed some level of relationship with at least some of them, probably sexually, but they'd be friendly. You work together. You get to know someone. They don't want him to die. I mean, not just because they're cold, calculating security personnel and now their profile is reduced because they have a public failure. That's a problem. But just in general, they probably, kind of like the guy enough. They didn't want him to die. And Erica probably knows that, is my guess. I don't know. It doesn't really matter. None of this has any relevance to the fact that Charlie was killed. My contention is that the security was not going to stop Tyler Robinson. There was nothing at all indicated that Tyler Robinson was going to do what he did. And there's no way to plan for that specifically. You can say that they could have stopped him from going on the Losi building. Maybe he would have gone somewhere else. We don't know if he had if he had contingent plans. We've no idea. No idea what would have otherwise happened. Maybe he throws a hand grenade. Who fucking knows? We don't know. So I don't like to get wrapped up in those hypotheticals. They're not useful. But security acting the way they did isn't weird. And that's where I wanted this stream to go. I talked a lot about it at the beginning. I'm going to talk about it a little bit more, but not as much as I plan to. And it's partly because the microphone is bothering me. The random popping and stuff. And I know having audio issues is a fucking nightmare. And so I'm probably going to have to somehow get a new mic to me ASAP. We'll figure that out tomorrow. But I am going to talk a little bit more about it because I want to just discuss a couple things related to this weirdness. I wish someone would go through, and I'm way too lazy for this. I wish someone would go through Candace Owens' statements and find everything that she has called weird. I know there's a lot of ways to do this, but everything that she's called weird in relation to this case. So we could just go through it point by point, because I can almost guarantee you it's not weird at all. Let's start with the paving over of the crime scene. Let's start with the paving over of the crime scene. Let's deal with it this way, actually. It's not a crime scene when they pave it over. It's not. I know many of you know this, but there are some of you out there who still don't. The assertion is that paving over the grass, the area where Charlie Kirk was shot and where he died, that they paved over that crime scene and that is strange behavior. And I'm here to tell you, it's not strange at all. And some people, I think it's weird because they don't understand the timeline. They don't know. Utah has rules about crime scenes. The investigators have to go in, collect everything, thoroughly document everything, collect everything they could possibly find as best they can. And then that has to all be made available to the defense whenever the defense wants it. But while the investigators are there, the scene is closed and the defense doesn't have access to it. Now, here's one reason that bothers some people, but you have to understand that a lot of times while crime scenes are being investigated, there isn't a defense. That doesn't exist. Tyler Robinson wouldn't even be assigned these lawyers for quite some time. He turned himself in, but many crimes are not solved that fast. You don't have someone turning themselves in. But the scene is processed really quickly because you can't have DNA evidence that's left out longer than 24 hours. Like if they're going to take blood from the ground or whatever, it starts to become unreliable. It starts to become hard to collect. It starts to become contaminated. Any number of things can happen. So there's no purpose in keeping a crime scene open for a long time. They need to collect all of the evidence that they can as fast as possible. In this case, they did. I think they shut it down within 36 hours. They released the crime scene. Now, the Utah rules also require, we haven't seen this. And when I say require, the Utah rules on crime scenes have a rule that says this, okay? I'm not making a full-on legal statement. It may be that they've violated the rule. I don't think so. We've not seen it, but when they release a crime scene, the releasing officer has to generate a report. That report includes a final walkthrough of the crime scene. They check off everything. They check with the investigators. They make sure that the crime scene's ready to be released. Because once they release it, they can't go back in it without a warrant because it's private property. So once they release it, boom, it's done. So they have a final walkthrough with an inspector, and that inspector generates a report. That report is given to the releasing officer. The releasing officer generates a report. I don't know. Somebody does. And then that report is going to be part of evidence. And then that the property is officially released to the owner. In this case, obviously UVU. Now, UVU is a highly trafficked public place, and they now have a biohazard because they have human blood all over the grass in a public area. They have to clean it up. It has to get cleaned up one way or another. It either has to get cleaned up by being paved over, or it has to be cleaned up with, some sort of liquid to wash it away. It has to be cleaned up. They can't just leave blood out. But here's the most important thing. Once it's released, it is the property owner's property. The defense can get access to the property. They can. If they are refused access to the property, they can get a court order that grants them access to the property. Property owner cannot stop a defense team, defense counsel, etc., from getting access to the property for some reasonable amount of time during the investigation. However, that rule does not require the owner to preserve the scene in any way. It does not. Because all the DNA, all of the particulate evidence, all of that's collected. All of that is collected by experts who do it. The defense has access to the scene for, literally, this is the rule, for things like line of sight angles and measurements, physical measurements, not for the collecting of DNA and particulates. And the reason is it's assumed that the expert forensic team of the state will do a good job. Now, you can say that they are not. Great. Except they do regularly do a fantastic job of collecting evidence. On occasion, we saw in Karen Reed, for example, the Karen Reed case, it's done in a shoddy way. But those are completely different occurrences. Remember, in the Karen Reed case, John's death was not treated as a crime scene at first. And some officer investigated it later. He determined it to be, I don't remember the exact circumstances, but the investigation didn't happen in the way the Charlie Kirk thing did. Remember, he's out there with a leaf blower trying to melt the fucking snow like an idiot. Way different scenario. So yeah, you can find examples where forensic investigative teams do a bad job. Of course, professionals do bad jobs all the time in every profession. That's why the private security thing is so baffling to me. It's like, you've been to a McDonald's, you know people suck at even easy jobs. Security is really fucking hard. But investigators are presumably experts doing an expert job, and they demonstrate that over and over and over in criminal cases all the time. So the defense doesn't have access to go in and try and find more DNA. I mean, incidentally, like hypothetically, they could find something like that, or hair or whatever, but that's not what their access is for. Once a crime scene is released, it is no longer a crime scene. It's over. It's done. And the owner has the right to do whatever they want with it. Again, with the limited caveat that if the defense requests access to it, they should be given access. And if they're not given access, they can go to the court and get access. They cannot be excluded from it as a matter of right. But there's no duty to preserve it. It doesn't exist. Anyone saying that paving it over or materially altering the scene of a crime is weird, it's never weird after release. They could have done it 5 seconds after release, and it would have been normal. We need to get away from conceding that anything about this is weird, because it isn't. Not because of messaging, not because of some movement or any gay stuff like that. It's literally just not weird. And we need to stop acquiescing to the idea that it is. And maybe people do that because they misunderstand. That's what I'm here to help with. Under the rules in Utah and everywhere, once a crime scene is released to the property owner, it's the property owner's property. They have full constitutional rights to it. The police cannot come back without a warrant that is justified by a new affidavit for probable cause. Not the old one. They can't reuse the old stuff. They'd have to get a new warrant with new reasoning behind it to come back. Once the police release the UVU property, they lose whatever rights their warrant granted them. Now, it's a public place. They could, in theory, come and look at whatever's there, right? Like, they can do that. There's some interesting stuff about DNA, though. In particular, the Fourth Amendment applies to your DNA. I don't know if people realize this. Like, not just the collection of your DNA, but your DNA itself has Fourth Amendment protection. They have to, it's weird because there's case law. This is in Minnesota at least. I would assume it's in every state. But in Minnesota at least, we'll limit it here. There's case law. It basically comes down to the question of, was the DNA voluntarily abandoned, right? Like if you're on a hot date with Riley Reid, you voluntarily abandoned some DNA in some places, presumably in Minecraft. But if you're stabbed in a hotel lobby, right? And your DNA is like, you drip some blood. That's not you voluntarily doing it. And the collection of your DNA has to be supported by a warrant. If a cop just comes in, he's like, oh, look, that's some blood. Let me grab it and drink it or whatever. They might run into a Fourth Amendment problem with your DNA. Like, let's say they test it and they find drugs. Like they run a drug test on it. What are they basing that off of? They can't then identify you and come after you because you bled in a hotel lobby. They would have to have a warrant for the blood. Now, could they get one? Sure. Possibly. Or they have to have an exception to the warrant requirement. I'm not trying to be overly precise here. But the point is, even though this is in a public place, we know that Charlie's blood was involuntarily deposited there. Now, his Fourth Amendment rights are kind of like, they're not great right now. They're not in good shape. He kind of died. So that's not that big of a concern. But what if they did find some other DNA? Like, just they go back and they just find something. Like they find a cup or something that was dropped in the panic. Now, see, this is complicated because if someone throws away a cup, their lips touch the cup, they throw it away, that's abandoning it. Willfully, you're giving that up. But what if you drop the cup because there's an active shooter? That's not abandonment necessarily. That's not voluntary and intentional. And you have a good argument. You have a good argument there that wasn't you giving up your DNA. You're going to keep that cup. It was special to you. So what are the investigators going to do? They may be able to visit the area, but they can't really do meaningful investigation without a warrant. So again, this is all just to go and say, they're not coming back. The scene is... That's annoying. The scene is released. It's gone. It is no longer a crime scene. And we need to stop with the idea that that is a strange thing. It's a normal thing. It's the normal process. Paving it over, changing it. Like if someone gets murdered in your house, you're going to probably paint you're going to probably paint the walls. You might change the carpet. Something like that. You say the cord has a short in it? That could be. I'll inspect it later and swap it out maybe. But this isn't weird. And the haste with which they release the scene isn't weird either. It's perfectly within the realm of releasing a public place, even where a high-profile murder takes place. It's outdoors. They can't keep the public away without massive expense. And even if they do, they can't preserve the integrity of any evidence that may be waiting around longer than a day or so. I was going to go into the bullet. I think people misunderstand the bullet and the gun. I think people misunderstand greatly. I think they misunderstand the bullet and the gun and how much evidence there is for this gun being the murder weapon. I was going to do that, but the microphone's fucking up. We're going to go ahead and end the stream. This has been a longer stream than I planned already. So we're going to end the stream. I'll do a separate stream or a video specifically on this stuff. And I want to start tackling these weird things. If anybody's enterprising and wants to put together a list in some way of the shit that Candace has said is weird with this case, we can one by one tackle those. No big deal. Same thing with Baron Coleman. With that, there's a super tip here.
Tyler used of an antiquated method of killing. A Jewish FPV quadcopter with a blam can be flown from concealment, zipped in fast, and he'd have been on his way, leaving everyone wondering what happened.
Nobody do this. This is not legal advice. But you put a pipe bomb and you tie it to a commercial drone and you fly it at someone and then blow it up. Actually, like, our military does this. It's inexpensive, like in the scheme of things. What is it? Are either of them not coffee? Okay. I'll drink this. No, I like this one.
That one has more. So I want to know if you like this one better. I know which one I like more.
I'll drink this one. Get out of here. Bye. Thank you. Love you too. Anyway, not legal advice, not practical advice. You cannot, or you could put a pipe bomb on a drone, just duct tape it to it. Who cares, right? And then fly the drone and blow it up. That's an easy way to off someone. There's all kinds of ways to kill somebody, and focusing on why anyone Casey McCoy says, no, Nick, you make a list. You make the big bucks here. Listen, I'm not making a fucking list. I don't want to go through all of Candace's bullshit. Holy crap. I would want to off myself immediately listening to that woman. God, she's an idiot. Okay. So, focusing on the method of why someone killed used a particular method to kill someone is kind of pointless. Tyler Robinson used an obvious method. He had a rifle, and rifles are good at killing people, and so he used one. This isn't a mystery. This case isn't a mystery. The gun is the murder weapon. I'm going to say it again. We'll do a whole segment once I fix this microphone issue on the gun being the murder weapon, because it's not close. It's not a question. The prosecution is 100% convinced that this is a murder weapon, and the jury will be too. I'm going to try and tackle some of the reasons people misunderstand it. But this static is getting worse and worse and worse. So we gotta wrap up here. Let's see. Right-wing extremist says Metal Gear Solid teaches us that anyone can be a sniper if they take enough pentazamin. I don't think I can have that. I think it's against my probation. Right-wing extremist says a lot of security protocols are based off bad things happening. Kind of like how H.W. Bush puking on the Japanese prime minister made them only have the president eat pre-prepared Air Force One made meals. Yeah. Yes. It's also like, you know, that one Japanese guy getting sworded through the midsection makes him keep people off the stage. Anonymous says, in terms of the Tyler video not being 4K clear, you just have to point to the Chandler Halderson case, where the video used was so bad they were using the light dark value of about 4 pixels to prove he barbecued his parents. That's a good point. I forgot that. But then you also, you know, you use the video of Kyle Rittenhouse, right? Kyle Rittenhouse's video, I thought was conclusive. I thought it was conclusive that he was acting in self-defense. I mean, that seems really obvious to me, always did. However, the state attempted to use video to show like Kyle Rittenhouse instigating something. It didn't end up working. But even that, which was an FBI drone or something, like it was fucking crazy, right? They had to be secretive because they had people that couldn't be identified come in and testify. They had to be secretive about that drone footage, but they ended up using it. That was high tech. That was high res. It was still grainy as shit. The state attempted to use it. Wasn't successful there, but grainy video is used in pretty much every murder case I've watched. Like a lot of these cameras are night vision cameras, not the highest resolution, low frame rates, etc. We had the was it the Curtis shooting, the theater shooting that I did with Bronca. The video in that was like a night vision, you know, an infrared camera, or not infrared. Well, yeah, I guess an infrared camera that was low resolution to watch him pull the gun and shoot. These ideas that we have to have 4K, high res, full light video, full color is crazy. We've never had that. That's. I'm gonna be done in just a second. I'll check it.
Hi, guys.
Get out of here. This idea that we have to have 4K resolution to figure anything out is insane. We've been figuring this stuff out for decades and decades and decades. Before we even had video, they found the murder weapon. One of the biggest clues to what the murder weapon is the class type. Even if they can't identify the specific gun, right? They know this is a 30-06 based on the bullet that they found. Now that, shockingly, they find a 30-06. That's way far from where it normally is. And it's exactly where they watch a guy run with a 30-06 and deposit it in the woods. They find it right there. It has a spent cartridge in it that they know was fired from that rifle. Now, they can't match the bullet to that rifle specifically, but that bullet's analysis is not excluding that rifle either. It's inclusive, but not conclusive, if that makes sense. They can't exclude, they can't exclude the rifle. They can't conclusively say it is the rifle, but the class characteristic, or the bullet from the rifle. Class characteristics of the bullet are that it is 30 caliber. Now, again, could it be fired by another 30 caliber rifle? Yeah, where is it though? Where is it? And why is there a spent shell casing? And why is this rifle here? And why does it have engraved bullets? And why did the guy who shot Charlie Kirk say he fucking did it with that rifle? And why in God's name are we sitting here fighting over this? Because the guy who shot Charlie Kirk isn't fighting over it. He's not defending himself on that. He did it. He said he did it. He knows he said he did it. But we're going to tackle all that stuff in some upcoming videos. There's a lot more Tyler Robinson shit coming tomorrow, assuming I can get this mic issue under control. And I think I can. Tomorrow, we're going to be doing a member show starring my dear friend Kurt, my best friend in the whole world. And his definitely not retarded spurg out in Melanie Little's chat. So we're gonna cover that. It should be good, wholesome fun. And by wholesome, I mean the wholesome of a fat man on camera. And should be some good laughs. A nice little break from Tyler Robinson. But Tyler Robinson is going to be a primary focus because this trial, which is going to happen absent a plea deal, is going to be big. And so we're gonna prepare for it. We're gonna watch it. I also like trials like this because it's fucking obvious. Like, I'm sorry. It's obvious. People are like, you're a defense lawyer, or you were a defense lawyer. You were always in favor of the defendant. It's like, well, not when the defendant's obviously fucking guilty, and it's pretty obvious. I'm convinced beyond a reasonable doubt right now. Now, the defense has the opportunity still to raise that doubt, and they always can. They always can do that and convince me otherwise. I'd be happy to change my mind. I just see no way that they're going to. I don't see them even trying to, but I don't see how they would. But that's the whole beauty of it. They get the opportunity to try. And if they try and they succeed, cool, I'll change my mind. I don't care if Tyler Robinson's guilty or not. Like, if he did it, I want him to be found guilty. If he didn't do it, I want him to be found not guilty. But the evidence in this case, at this juncture, is so overwhelming that he's guilty. And it's not, none of this is hard. This isn't hard law. This isn't difficult evidence. It's not even ambiguous. But people are acting like this is a mystery, which is wild. All these people, imagine how many people are going to be sitting there watching this trial confused as fuck when the jury comes back. Like, the jury's going to take a while. Let me just put this out there. If the death penalty is on the table at a jury trial, it's going to take a while. Jury's finding a death penalty, assuming they, I don't know exactly how Utah does it, but assuming that the jury has knowledge that the death penalty is part of the sentence for the aggravated murder, and the question of whether they find the aggravator in there. If the jury's aware of the death penalty, they will the deliberation's going to take a while, most likely. They take that very seriously. Juries, if they're the decider, they kill a man. Usually, rarely a woman. But they kill a man. They take, that's not something that people do normally. So it'll probably take a while in deliberation. If the aggravator's off the table, like judicially off the table, and it's just murder one, this case will be resolved real fucking fast. But either way, it's going to be a bunch of people out there thinking that the jury's going to come back with a not guilty verdict. They're like, yeah, our boy's not guilty. They don't have a murder weapon. They'll have testimony from expert after expert after expert explaining that that's the rifle. We're really fucking sure of it. And they'll tell them exactly why. And they'll be like, nope, Candace Owens said no. They can never prove this. Wait, how'd they find him guilty? There's going to be so many baffled morons out there. It's going to be great to watch. All right, couple more quick chats and then we're done. Maverick Cuba says, next time on Dragon Ball Z. Right-wing extremist says, who's better at trials, Kurt or Russell Greer? Oh, I forgot. That's another thing we have. I do have the audio. 2.5 hours of Kurt in court. 2.5 hours. It's audio only, but it's Kurt in court. So we do have that as well. Maverick Cuba says, next you're going to say Lindsay Clancy is guilty. I didn't watch the Lindsay Clancy trial. There's plenty of people covering it. I don't, that trial wasn't all that interesting to me. I mean, a little bit, but at the same time here, I'm just going, okay, well, she goes to prison or she goes to a psych ward, and I don't care which one. She murdered her children, 3 of them, intentionally. You can say she was temporarily insane. Okay, so she needs to be committed forever, or she needs to go to prison forever. I don't care which. Sorry, I don't have like this. I have lots of compassion for people. I think that if her insanity caused her to kill her children, blah blah blah, she still did it. She's still a danger. I don't know that you get better from doing that. I don't think, like, what is the revelatory fix? Like, oh, you know what? Actually, now I'm not someone who murders children. I feel like that would only increase the odds. Like, well, I really am a piece of shit, I guess. She tried to kill herself and failed. So she's combined to a robot scooter or whatever for the rest of her life. I don't care what happens to her, though. The people out there like calling her a hero and like some symbol of women's rights, or every woman out there should be offended. Postpartum's it's a real thing. Postpartum is horrifying and terrifying for the people involved. But here's the thing with these conditions and afflictions that make someone dangerous. The victims are still victims, and justice still requires recompense for the victim and a protection of everybody in the future. If we just went, well, are they likely to kill again? If no, they don't go to prison. A lot of murderers would be out. A lot of people only murder one time. It's specific circumstances that led to it. Okay. Probably not going to murder again. Some of them are really likely to murder again, though. But it doesn't matter. Their victim's life was ended. They need to be removed from society. They don't belong there. Women who have suffered through postpartum, who know about the like cold indifference that they feel towards the child, which override like the love and adoration that you have for your child often overrides the frustrations and the things. That's why postpartum is so dangerous. It creates an apathy towards the child. So they maybe aren't getting nourished enough, or the parent isn't as careful or whatever. But tons of women go through postpartum without murdering their children. They may not be the best moms during that time. They need support. It's real. They need counseling, therapy, whatever it is that they need. But they don't end up murdering their children. And they should be really, really offended that the symbol for postpartum depression and its reality is a fucking murderer. Like that is not the symbol. That's not it. Because the overwhelming majority of postpartum sufferers do not murder their children. He said, they may not be the best parent in that time. And hopefully there's a co-parent, like a dad, right? Who can take over. And that can be really stressful on the couple too. Like, obviously, because the dad's doing a lot more work. And if the dad's typically like the breadwinner, plus he's got to watch this new kid and he knows that like something's going on, it can be really stressful and stuff like that. It's a real problem that should be, there should be awareness, and it should be diagnosed properly and assessed. And if the people like failed at doing that and they have some culpability, good, fucking burn them to death. I don't care. But she should not be some heroic symbol of womanhood because she's a failure of womanhood. She failed. Tons of women out there go through postpartum and they get through it. Lots of women, they may never recover from it. And those women don't kill their children. They might have someone else take over parenting, and that's okay, right? The child gets a chance. The failures harm their children. Catastrophic failures murder them. Postpartum is not an excuse for murder. And she should be removed from society, no matter what the answer is. There's no question that she killed her kids. Nobody made her do it. Nobody made her do it at all. And she knew it was wrong. She tried to kill herself. Don't sit here and come at me with, the killing herself was part of the depression. No. If the killing herself was part of the depression, she would have just killed herself. Killing the 3 children, knowing the wrongness of that. That's why she was killing herself. She didn't otherwise kill herself. It's not like she was gonna, she could have just done it, she could have just offed herself. But she didn't. She didn't do that. We don't need to reward or accolade or anything this monster. She needs to be dealt with in whatever way justice demands. If she's not guilty by reason of insanity, she is dangerous enough for civil commitment for the duration. And may it be short. I don't care. If she is guilty, give her the fucking chair. Wait, she's already in it. Just overload the battery. Drive her off a cliff. Who gives a shit? What an awful human. All right. That said, thanks for hanging out, guys. I really appreciate it. We have one more. Maverick Cuba says, I'm still trying to figure out what postpartum means. Postpartum depression is something that some women go through after birth. Postpartum means after birth. So they give birth to a child and then they suffer an intense depression, often resulting in an apathetic or even hostile view towards the child. I would contend as a layperson that it's mostly apathy, but all the annoying things that kids do aren't overcome by your typical loving feelings. Like you don't have those loving emotions towards a child. The mother tends to be resentful. And again, you think about it, they have to do all this stuff for something that they're having psychological trouble caring for at all. They don't care about the child. It's not women's fault. They don't earn this. It's not like, I don't know it to be predictable or anything like that, or even preventable, but it is treatable. A traditional family with another parent is helpful in it. But either way, it's something that happens, and it is a real problem. But that doesn't mean that people who murder a child are not murdering a child. All right, Kate of the Swiss says, hopefully Clancy's cell is covered in the photos of her dead children before and after. That's awful. But she probably is incapable of caring about it. Maverick Cuba says, I heard women who suffer from it bred with betas. Yes, that's what it is. No, man. I've known women who've gone through it, and you know what? Like, their family situations run the gamut of traditional to like single mother, like blended families. It can be anything. It can be anybody. There's probably some predictor of it, but I'm not aware of it. And it's awful. It's awful, especially because like the mother is often aware of the condition, especially once diagnosed. They know why they don't care about the kid, but like they can't do it. And there's nothing they can do to make it work. So it's hard to watch. It mostly takes time, support, care. And then, that's it. Okay. Mike's going out. I got to go. Hope you guys have a great night. We'll talk very soon. Peace. Peace.
I am not suicidal. That's what I would like to say. Okay. I am not suicidal. Okay? I am not suicidal. I am innocent, and I am not suicidal. And I am not suicidal. And if anything happens to me when I go in there, I did not do it to myself. And you must all know that. I am not suicidal. Okay.